Items for delivery of order, item number 40, CRPIO 349 of 2024.
Petition allowed.
Okay. Item 41, bail application 2568 of 2024.
Petition dismiss. Yes, any mention?
My lord, in regard to item 44 of supplementary list, my lord, I am appearing on behalf of the respondent. Today I have got some difficulties, my lord. If your lordship accommodate me till Monday, my lord.
Next Monday?
No, yes, coming Monday.
Possible? Okay. Yes, madam?
I'm,
You are in different matter.
no, yes, ma'am.
Mr. Dotto, you inform the other side.
Yes, yes.
Acha, okay, okay. As agreed by learned advocates of both the parties, recessal is the matter on Monday.
Obliged.
3rd September.
Yes,
May I please, Your Lordship, I beg to mention item number 46 of supplementary list, my lord, today's list.
yes.
At this matter, I am appearing for the respondent for the first time, my lord.
Ah,
I want to file an affidavit. My learned friend is also there, my lord. He has also
Okay.
answered.
as prayed for by Mrs. N.S. Thakuria, learned counsel for the petition respondent, recessal is the matter
After vacation, my lord.
after vacation. So as to enable Mrs. Thakuria to file her affidavit in opposition.
Lordship,
Okay.
there's the interim that may be continued.
Interim.
Yes, sir.
Okay. Till then, interim order passed earlier shall continue.
Obliged, my lord. May I please, Your Lordship?
My lord, I beg to mention in CRPIO for listing on Monday, my lord.
When?
CRPIO for listing on Monday. And the next date in the lower court is on 25th, my lord, so it is an urgency.
Possible?
There will be
Okay,
many cases.
okay.
Obliged. And my lord, I beg to mention RFA for listing on Monday.
Monday not possible. After vacation only.
Tuesday, my lord.
No.
It's for withdrawal, my lord.
Withdrawal. Okay. Oh, if it is for withdrawal, then okay, on Tuesday.
Tuesday. Obliged.
May it
Yes.
please your lordship. Lordship, in item number 35, we have filed affidavit in opposition against the IA. Lordship, that may be taken with the case record.
35.
Yes, Lordship.
Your good name?
J. Gayon.
Ms. J. Gayon, learned counsel appearing on behalf of?
Right. Yesterday we have filed the.
Yesterday?
Yes, Lord.
Acha, okay. Okay.
Please, your lordship, I have for listing
When?
Monday,
Monday not possible.
on Tuesday or
On 30 September.
30.
May I please your lordship, MFA 2420 for listing on 23rd September.
On 27.
Okay, oblige your lordship.
May I please the lordship? Lordship listing or back to mention listing of RSA for any date next week.
On 30.
In which column? Order column or hearing?
Admission.
Admission?
30.
Much obliged.
Items from daily list, item number 1. Promotion, bail application.
May it please your lordship. Lordship, regular bail application, lordship. Petitioner has been behind the bar for 3 years, 2 months, 8 days to date. Lordship may call for the LCR.
Okay. Third miss, your good name?
And Sultana.
Learned counsel for the accused. This application under section 483 services preferred by 483 of the BNSS referred by accused Amir Ali, who has been languishing in jail in connection with NDPS case number 1 of 2022. Under section 22, between bracket C, stroke 29 NDPS Act, pending before the Court of Learned Additional District in Session Judge, Kamrup. Session Judge number 5, Kamrup and Guwahati. Having heard the submission of learned advocates of both sides, it is provided that provided that the registrar shall call for the scanned copy of the record along with up-to-date status report fixing the matter
On 23rd October. Item 2,
Lordship, can it be earlier, little earlier? It's from Kamrup Metro. The record.
Possible.
on 3rd. On 3rd of October. Item 2,
Wait, this is a lordship. Madam, this is our third bill application, madam. And earlier lordship was,
What is the ground?
madam, undue delay in trial, madam. That is the sole ground we have taken in this application.
Pardon?
Undue delay in the trial, madam.
Undue delay.
Yes, madam, I am behind the bar for last 916 days, my lord. And lordship, earlier bail application, lordship was pleased to reject by order dated 22/02/2024, which is at page 44. And lordship was pleased to direct that record should be taken to section 309 of CRPC, my lord. Even then, my lord, out of 11 witness, after that order, only one witness has examined, my lord. So I
This
pray
is-
before a lordship to call
How many witnesses have been cited in the search sheet?
11, my lord.
Out of 11, how many witnesses
Three
have been
witnesses, my
examined?
lord. Three witnesses only.
Three.
Three witnesses. And my lord, charges was framed long back in the year 2022 itself, my lord.
2000?
22, man. 26/8/2022. charges
Mr.
were-
M.S. Odore, learned counsel for the accused, and Mr. K.K. Das, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is referred by accused Liton Mia, who has been languishing in jail in connection with special NDPS case number 47 of 2022 under section 22C, 25, 29 NDPS Act since 19/3/2022. Further, having heard the submission of learned advocates about the parties, it is provided that registrar shall call for the scanned copy of the record as well as the up-to-date status report fixing the matter on
21st October,
My lord,
short
can
date,
it-
short date.
my lord, can it be before
on
vacation?
4th October.
4th October. Deeply obliged.
Item 3,
May it please your lordship,
Yes,
matter will pass over for the time being.
item 4, obliged.
Lordship, my senior is engaged in another matter. The matter may be adjourned for the time being.
Item 5,
May I please, your lordship, it is the second bail application, PRS bail application. Your lordship, charge sheet has already been filed on 30/11/23, annex of 4. Your lordship, if your lordship may please to go through the FIR, page 17, your lordship. There is nothing, no elements of an offense, your lordship.
then why search sheet is submitted against you?
Such sheet also same, your lordship. Your lordship may also see the charge sheet.
In that case, you can challenge the entire proceeding.
Your lordship, I will appear before the trial court, your lordship. The trial court shall consider my bail application, your lordship. Next date is on Monday,
Sir, your good name, please.
23rd. Next date is on 23rd.
Your good name, please.
R. Majumdar.
Har Mazumdar, learned counsel for the applicant. And also heard Mr. K.K. Das, learned additional PP for the state respondent. This anticipatory bail application under section 482 of the BNSS 2023 is prepared by the applicant Amir Hussain, who has been apprehending arrest in connection with Ding PS case number 170 of 2023 under section 376 511 IPC, read with section 8 of the POCSO Act. Alright, having heard the submission of learned advocates of both sides, it is provided that Mr. It is solicited case.
Yes, your lordship. It
It is
is not
provided that
constituted.
Justice shall call for a scanned copy of the
75,
record
20.
along with the case diary
Patient.
fixing the matter on probably before vacation.
Your lordship, next date is, it is proceeding before the special judge, Nagaon. Next date is on Monday. I will appear and will try for.
Sorry, we without perusing the case diary, we will not grant any relief to you.
Item 6,
Okay, please, lordship. 482 BNSS, my lord. The petitioner is not named, FIR named accused, my lord. He is very much innocent, but one additional has been visited to the house of the petitioner. That is why, my lord, filed this instant petition, my lord, for protection. Similarly, my lord, the other,
This is first application.
my lord, my lord.
Yes, Mr. Das have produced the case diary. When?
Lordship.
Heard Mr. P. Islam, learned counsel for the applicant. This application under section 482 of the BNSS 2023 is prepared by applicant Saddam Hussein, who has been apprehending arrest in connection with Jagirur PS case number 9 of 2024 under section 120B, 420, 468, 471 IPC. Further, having heard the submission of learned advocates of both sides, it is provided that Mr. Das, learned additional PP, shall produce the case diary before this court on
30th September.
when?
30th September, 30. Item number 42,
He is not a FIR named accused, my lord. Interim may be ordered.
Pardon?
Interim may be.
No interim.
item number 42,
May I please, Lordship? Lordship, in this matter, learned additional advocate general D. Mozumdar will appear, Lordship. He is election honorable for maternity pass over for the timing. Lordship.
item 4, admission, item 7, parthead matter.
Last occasion, my lord, I was supposed to produce some
Yes.
cash flow, my lord. Super, GDS. This is a list, my lord. Thereafter, Lordship will find the case law. My lord, this 84 for SCC, this case I am submitting here, my lord. This is our regulation is a statutory regulation, my lord. Statutory rules, my lord. That's why, my lord, he has not challenged these rules also, my lord. So, para 20, I have mentioned it, my lord, the gist, my lord. Next notification, Lordship, can you see?
See, annexer 2 is the notification.
Yes, no notification. Yes, his annexer 2 is a communication. Petition from here. He says, my lord, 82 the petitioner appeared in HLC examination and 84 submitted an my lord, application for correction of date of birth. I have gone through the my lord records. It is not this annexer. Lordship, kindly see. I don't know where he has got annexer 2. This annexer is my lord sent by the. I don't know the signature is not there. I think the principal. This is my lord, this foundation of his claim. Foundation of the petitioner's claim for date of record, correction of date of record, this is not a process. It is not based on records. Because this is not a procedure. This is not a procedure, my lord. Procedure is, my lord, when any clerical error or any, my lord, omission or commission calculation is wrong done, then in case, my lord, petitioner has to apply to the board through the head of the institution where she appeared, through the inspector of school to the board within 3 years. Will come to the our cash flow and production. 3 years. But this shows, it is only addressed to the Board of Secondary Education 26 May 1984. But nobody has endorsed, the inspector has not, my lord, written anything and there is no report from the inspector of school that I have
So
verified.
as per your regulation, it has to be forwarded by the head of the institution.
Through the inspector of school to the board within
Yes.
3 years. Time limit is there.
Mhm.
But in 84, they are saying within time limit, but this is not received by the board. We have stated in our application and there should be a fees to be enclosed along with it. They will have to, for processing the application, they have to pay a fees. This is a regulation is still there. So that is also not there. Petitioner has not annexed anything that we have paid 50 rupees, 10 rupees like that, nothing. And that's why, my lord, this is not based on any records. They only forward that so and so is rule number so and that admission 82 and actual age is 16 years, 1st March 1982. What is this? What on what basis that had been placed allegedly submitted to the board? I think that was not prepared. I think it was not sent to the board. They only kept in the pocket of the petitioner, my lord. Now they are saying that we have a record. We have an application. 1984, within 3 years, we have applied it. That is the best. This is not forwarded by the inspector of school. There is no endorsement. And also, my lord, inspector of school has to submit a verification report seeing the registration. That was not done. How we will believe it? Assuming, not admitting, my lord, assuming that was submitted before the board. How we will believe, my lord? On what basis we will correct the date of birth? Simply said his date of birth is 16 years, not 17 years. Can it be, my lord? No, my lord. That's why, my lord. And now she is going to be retired and belated stage and the fag end of this career, date of birth cannot be considered, my lord. Cannot be correct. I mean, I will produce. Lordship, can you see our my note, my note, my lord. 1984 for SEC, my lord, this is I am submitting for that. Our regulation is a statutory regulation, para 20. 20, my lord, view the setting. We are unhesitatingly the opinion that the regulation made by the board under section 36 are in the statutory rules and they have the full vigor and force of subordinate legislation made by the delegate duly empowered in their behalf by the legislature. The SEBI also, my lord, our regulation is made under section 24(1)(2) of the Assam Secondary Education Act 1961. That's why this regulation is as per the Assam Secondary Education Act 1961, subsection section 24, subsection 1 and 2. Our empowered the board to make regulation. And next notification, let's kindly see. Notification 1975. SEBI has fixed the time limit for 3 years for correction of age from the date of commencement of the examination concerned. On expiry of the time limit, no application for such correction will be admitted. The application must be accompanied usual fees. Kindly noted, usual fees in cross postal order in favor of the secretary. These notifications were forwarded to Sower, principal and headmaster of all high school. We have given 75. And next case law, Lordship, kindly see, 2003. I am giving the gist, my lord. Lordship will have this, my lord, in the from the 2003 12 SCC Board of Secondary Education. That was, my lord. We SEBA filed an appeal before the Supreme Court. Supreme Court say, my lord, Lordship, kindly see paragraph 13. 13 we have made. I am reading it, my lord. The High Court formed the opinion against the board, holding that 3 years limitation for correction of date of birth depriving relief to the candidate is not reasonable. But the Supreme Court held that 3-year period provided by the regulation is very reasonable period. On the very date of issuance of the certificate, the student concerned is put to the notice as to the entries made in the certificates. For everyone remembers his date, age and date of birth. The students would realize within no time that date of birth is entered in the certificate is not correct. If that be so, once the certificate is placed in his hands, based on the certificate, the applicant would seek admission elsewhere in the education institution or might seek a job or career where he has to mention his age and date of birth. If he failed to notice the error on the date issuance certificate, he would come to know shortly thereafter. Thus, the period of 3 years is prescribed by the regulation is quite reasonable. It is not something like prescribing a limitation for filing a suit. The prescription of 3 years lying down of the dividing line before the which the power of the board to make correction ought to be invoked and beyond which it may not be invoked. Belated application, if allowed to be received, may open a Pandora's box. Records may not be available and evidence may have been lost. The prescription of 3 years bar takes care of the all situation. The provision is neither illegal nor beyond the purview of the section 24 of the Act. Also cannot be called arbitrary, unreasonable. Appeals are allowed and judgment is set aside. These are our only for limitation pure. Next case, Lordship can say. I am giving the this, my lord. My whole case is before your Lordship. 2020 SC 940 Bharat Cooking Lordship. This is an important case, my lord. Para 7. This case, what happened, my lord? The learned single judge, but the facts of the case is that, my lord, in this case, High Court directed the corrected date of birth as 20th January 1955 in place of 4/3/1950. Petitioner got appointment on 27/2/1982, retired 2010. Just prior to the retirement of his 2009, he sought for change of his date of birth, entering the records which were rejected by the appellants. Appellants secured verification of date of birth from Bihar School Examination Board partner. Found date of birth is 55. The single bench of and division bench of the High Court are in favor of the writ petitioner. Being agreed, this appeal filed by the appellants before the Supreme Court. Para 7. The learned single judge considered the representation made by the respondent in the year 2009 and verification from the school. The Supreme Court says that it was not appropriate in the present facts within 3 decades after 30 years when 3 decades elapsed from the date of employment. The position is well here, Lordship minded ballot. The petitioner has not mentioned which per any ballot where the petitioner got employment ballot, where he entered in the job ballot, that is not mentioned anywhere. Perhaps he is going to be retired, but before more than 30 years, she joined in the service. The position is well settled. If the date of birth is entered in service register, a change sort cannot be entertained at the fag end of the service after accepting the same to be correct during entire service. The respondent in his own handwriting indicated date of birth as 4/3/1950 in the service book, merely because a verification is made from the Bihar School Education Board, and even if it is from the date of birth, confirmed the date of birth is in 1955, such change that at that stage was not permissible. Para 19. Correction of date of birth at fag end would be at the cost of large number of employees. Therefore, any correction at the fag end must discourage by the court. Date of birth of public servant has the same reaction. In much as others waiting for years below him for respective promotion are affected in this process. Some are likely to irreparable injury because of correction of date of birth officer concerned. Continues in the office, some cases for years. Within such time, many officers who are below him in seniority waiting for their promotion, they may lose their promotion forever. Accordingly, according to us, this is an important aspect. We cannot be lost sight of by court while examining the grievance of public servant regarding date of birth. Claim for correction of date of birth has been made in accordance with the procedure prescribed and within time fixed by the rule or order. The onus is under applicant. So this case, para 19 Lordship policy, why the date of birth is not corrected in the belated stage? Because another person is waiting. So I am working as a superintendent of taxes. The under additional superintendent, he is going to be retired after 1.5 years. Then within a year, if it is his date of birth is extended, then he will not get any promotion forever. That's what court says. In military says date of correction of date of birth is impermissible, not permissible. And para 9, this Bharat Cooking case para 9. Court held that even there is good evidence, Lordship Kali noted, even there is a good evidence to establish that the recorded date of birth is erroneous, the correction cannot be claimed as a matter of right. Time and again, this court has expressed the view that if a government servant makes a request for correction of date of birth after a long time of his induction to the service, particularly beyond the time fixed by the employer, he cannot claim as a matter of right the correction of date of birth even he has good evidence to establish that recorded date of birth is clearly erroneous. No court or tribunal can come to aid of those who sleep over their own rights. Because suppose assuming not admitting ballot, in 1984 she submitted an application. Till 2024, she did not make an inquiry. She was sleeping over her right. What was happened? She did not pursue. This is, Supreme Court says, the person who are sleeping over her right or his right, court and tribunal would not come to aid to him. And division bench of the court, therefore, this is a case. And next case, Lordship side 2005-6 SCC, there's Shivam Upanar. This case is also mentioned in this earlier bar cooking case. Malad, in this case, date of birth, say reaction, correction of date of birth is to be as per case law. The say reaction, Malad. Say reaction means, Malad, court, while considering the correction of date of birth, court will in slow because say reaction means that's why I'm explaining it, Malad. Another person is waiting for promotion, Malad. This person, if they holding the post, the person who claiming correction of date of birth is corrected. Suppose he got 2 years enhanced, his age, then next person will not get promotion. That's why court said it is impermissible. Impermissible, Malad. 2005, I'm reading it, Malad. Yes, showing there. See. Oh, yes. 2005, I'm reading the paragraph, Malad. Para 9. I'm reading Lordship. Lordship will see later, but I'm reading my part. 9. An application for correction of date of birth should not be dealt with by a court or tribunal or the High Court, keeping in view only the public servant concerned. It need not be pointed out that any such direction for correction of date of birth of the public servant concerned has the same reaction, inasmuch as others waiting for years below him for their respective promotion are affected in this process. Some are likely to suffer irreparable injury inasmuch as because of the correction of the date of birth, the officer concerned continues in office in some cases for years, within which time may officer who are below him in seniority waiting for the promotion may lose the promotion forever. Cases are not unknown when the person accepts appointment keeping in view that the date of retirement of his immediate senior. This is certainly an important and relevant aspect which cannot be lost sight of by the court or tribunal while examining the grievance of the public servant in respect of correction of his date of birth. As such, unless a clear case on the basis of clinching materials which can be held to be conclusive in nature is made out by the respondent, that too within a reasonable time as provided by the rules governing by the service rules, the court and the tribunal should not issue a direction or make a declaration on the basis of materials which makes us claim only plus review. Before any such direction is issued or declaration made, the court or tribunal must be fully satisfied that there has been a real injustice to the person concerned and his claim for correction of date of birth has been made in accordance with the procedure prescribed and within time fixed by the rule or order. Within time means 3 years we have prescribed. Rules, there is the procedure. And why it cannot be, Supreme Court says, because, my lord, same system and petitioner by not correcting date of birth, how she will prejudice, there is no mention at all. How she will prejudice, how the petitioner prejudice, suppose date of birth is corrected, she will get 1 more years of service gain. But how she will prejudice if not corrected? Court has examined all these things within the time fixed order. If no rule or order has prescribed, been framed or made, prescribed the period within such period, application had to be filed. The application must be within at least reasonable time. The applicant has to produce the evidence in support of such claim, which may amount to irrefutable proof relating to his date of birth. Whenever any such question arises, the onus is on the applicant to prove about the wrong recording of the date of birth in service book. In many cases, it is part of the statutory or the part of the public servant to approach this court and tribunal in the aid of their retirement. The court and tribunal must therefore be slow in granting any interim relief or continuation in his service unless prima facie evidence and impeachable character is produced because of the public servant succeeds. He cannot claim. These are 2005 and next 2010.
No, not necessary to multiply the decisions.
My lord.
Not necessary to multiply the decisions.
My lord, pardon?
Not necessary to multiply the decisions.
Yes, yes. Yes, anyhow,
the law is well settled.
Yes. Laws will understand all these things, my lord. That's why, my lord. And other cases also 2005 and 2010.
Not necessary.
Yes, yes, I have given it. Laws you can go through it, my lord.
Yes.
So, my lord, my humble submission for lordship, my lord, they are only claiming that date of birth correction only on the basis of 1984 letter. That is why we deny that we have not received, there is no record at all. And there is no evidence that she has on the, with the application submitted fees like that as per regulation. That's my humble submission, my lord, and flag and career is not punishable.
Okay. Yes.
Lordship has already had
Okay,
the
so,
judgment
Malad,
referred by my magistrate.
He's appearing for the school, my lord.
Only one submission that the petitioner has not.
Yeah.
My lord, the writ petitioner in this writ petition has not prayed for any certiorari challenging the order of the my lord Seba dated 4/4/2022, my lord. The my lord Seba has passed the order after my lord perusing the school admission registers, wherein the my lord date of birth of the writ petitioner has been recorded as my lord 10/12/1964, my lord, and this was based on the school admission register. And my lord, that has not been challenged. Only my lord, they have made an prayer for my lord recalling of that order, but no certiorari has been prayed, my lord, in this writ petitions. And my lord, so far, my lord, in the last occasions, the learned counsel for the petitioner has submitted that the writ petitioner was, my lord, admitted in class 5, my lord. I have received instructions from the my lord present headmaster that the initially the my school was a 3 classes high school, my lord, class 8, 9, 10. Subsequently, in the year 2017, another school has been amalgamated with the my lord present high school, my lord. So prior to that, my lord, it was a 3 classes high school. So the writ petitioner was admitted in the my lord class 8, not in 5, my lord. This is my humble submission. And others, my lord, I have adopted the submissions made by my lord.
Lordship, basically, Lordship, the judgment referred by my learned friends, all are relating to correction of date of birth in service record. Here, this is the not case of the petitioner to make a correction of her date of birth in service record. Lordship will see our prayer. Our only prayer is to Lordship, correction of date of her birth on the basis of the application submitted in the year 1984. She Lordship passed our HSLC examination in the year 1982. And immediately after passing Lordship, within the time that my learned friend is submitting, their stipulated time is 3 years. So there is nothing, Lordship, to dispute that it was filed in time. So since the application was filed in time, non-consideration of or non-attending the application submitted by the petitioner cannot be Lordship attributed the fault to the petitioner. It is the fault of the respondent. So Lordship, there are several judgments of the apex court that if representation or application is submitted in time, it is the duty of respondent state authorities to attend the application or representation in time. That cannot be attributed to the applicant.
But they have denied the receiving of the.
How can Lordship they deny? First thing, they have admitted in their affidavit in opposition that might be it is misplaced. If it is misplaced, how they can Lordship deny that it was not submitted, not received?
Not only by clearly
Lordship, I will go by their affidavit. Now, Lordship will find the affidavit. What is their defense? Affidavit in opposition filed by respondent number 2. Lordship will find the affidavit in opposition filed by respondent number 2 at
Yes.
paragraph number, Lordship, 6. Paragraph number 6, just I am reading, Lordship. Lordship, with regards to the statement made in paragraph number 5 and 6 of the writ petition, the deponent begs to state that application dated 26/5/84 regarding correction of date of birth of the petitioner could not be located in the office of the court. The reason may be the petition either not received or misplaced. Could not be located doesn't mean that we didn't submitted any application. They could not locate it, Lordship. How they Lordship arrange their application or file, that is up to them. They will know better than us how they have Lordship placed or arranged their documents. So could not be located. So it is not stated that they did not receive any application. Whatever their allegation, whatever their denial, Lordship, that should be specific. First thing. And in their affidavit, Lordship, they have not taken any such plea that whatever judgment, Lordship, my learned friend has referred, 4-5 judgment that he has referred, Lordship, regarding only the date of birth correction in the service record. This is not the case of the petitioner to make her date of birth correction in the service record. This is the only case that Lordship, since in her certificate of HSLC examination, it was wrongly recorded, it should be corrected. Lordship will see our prayer. Prayer will find Lordship starting from page 14 of my writ petition. A writ of in the nature of mandamus directing respondent authority to correct the age of the petitioner in reference to the office communication dated so and letter dated so issued by the office of headmaster of Pub Bajani, Gopalthan Balika Vidya Mandir. This is the basic prayer, Lordship. All are related to same prayer. Only to correction of her date of birth in her Lordship as per application dated 26/5/84. Nothing more relief has been sought by this petitioner Lordship in this writ petition. I don't know Lordship, why my learned friend is reiterating that if the date of birth is corrected, the other person who are in queue of the promotion, they will be deprived. We are not seeking any promotional benefit, Lordship. We are only seeking if my date of birth is corrected, then Lordship, it will be clear that I was born in the year 19 so and so, whatever my actual date of birth is. Even Lordship, we also Lordship produce our horoscope also as per direction of the Honorable Court. Along with the Lordship application data 84, we have also bring on record by our additional affidavit our horoscope, Lordship. Number 3, Lordship, initially before filing this application, filing the reply, the school headmaster who has Lordship filed his affidavit in opposition as a respondent number 3, he Lordship certified that the application that is referring by the petitioner is true and genuine, and it was issued by the earlier headmaster. Lordship will find that in the endorsement Lordship made by respondent number 3 at page 24 of my writ petition.
Yes.
Lordship. So this is final copy I am reading, Lordship, the manual portion. Certified to be true copy of the original copy of the letter issued
Page
by the
number, page number,
Lordship. So
page
Lordship,
number.
page 24, annexure 5. So Lordship, it was certified to be true copy of the original copy of the letter issued by the Ramanath Sharma, ex-headmaster of PBG Balika Vidya Mandir HS on 26/5/84 and received by me on the 5th of November 2020. Letter of Sanso, St. Cross. Now, Lordship, we have also Lordship this they have issued a letter to this petitioner by the office of the Lordship headmaster of state school regarding letter issued by Ramakanto Nagar. So he has specifically mentioned Lordship, next page of 25. In pursuance of your kind letter dated 5th of November 2020 received on the same day, I have come to know that a letter was issued by Ramanath Sharma, ex-headmaster PBGB BMHS on 26 May 84 requesting for the correction of the age of Anju Rani Boyso, who passed the HSLC examination in 1982 from the school. In view of this, I hereby certify that the above mentioned letter enclosed with your application is true copy of the original letter. So, Lordship, after issuing this letter, the headmaster, Lordship, not Lordship, without going through the record, has issued this letter. Headmaster initially Lordship verified all his school record and issued the certificate. After issuing certificate, Lordship, might be Lordship because of pressure from the higher authorities. Now he is trying to deny that person that there is no such application received by the school. How it can be, Lordship? Let the headmaster person be appear, Lordship, to approach to address this issue that whether he had issued this to application or endorsement or letter to the petitioner, Lordship. Let him appear and personally and Lordship address the issue. How now he can deny, Lordship? Secondly, Lordship, in their affidavit, they have enclosed the Lordship school register of class 10. Wherein, Lordship, we have replied to their affidavit in opposition stating that no, we admitted in the state school not in 8 but in 5. Why they are silent to this aspect, Lordship? They should have brought on their affidavit that no, this petitioner admitted in the state school in class 8, not in 5. But they are silent. We are only, Lordship, seeking justice. Lordship knows prior to 40 years ago, Lordship, the condition of a rural schools, Lordship. If a person, Lordship, admitted in class 5 and promoted to class 6 and 7 or 8 in the same compound, basically, Lordship, it goes one by one step usually, Lordship. No further, Lordship, year-to-year admission was necessary. So since Lordship, he admitted in the year 19 in the state school in class 5, after being promoted to class 6, 7, and 8, Might be there is some typical mistake or whatever lordship they have committed. They are now lordship, initially they have admitted that it was issued by the school authority.
Okay, okay.
Lordship. So this is also basic prayer of the petitioner is only to correction of date of birth, not his service record lordship. And my learned friend is only the judgment that has been referred by all relating to lordship correction of date of birth in service record. We are not seeking any such relief in this petition lordship. If we subsequently lordship, if we come later on seeking our correction of date of birth in service record, then they will get that opportunity to object our lordship correction of date of birth in our service record. So lordship, and the application lordship has already gone through that application. It was lordship forwarded to the secretary of the board through the inspector of school. Everything was followed lordship. He has submitted that it should go to the inspector. It is through the inspector. Lordship has already seen of annexure 2. It was lordship approved to the secretary board of secondary education through the inspector of school so and so, not by the petitioner itself. Lordship.
Okay.
So lordship, humble
But-
prayer lordship, let the yes lordship.
Heard Mr. Kolita, learned counsel for the petitioner, and Mr. Setia, learned counsel for the
I
respondent
have
number
pointed my
2.
lordship.
And
Lordship can,
Mr.
page
Swarna?
32, so we have passed my lord speaking order, page 32, lordship can go through it. It will reveal all these things, my lord.
Okay. Mr. R. Sharma, learned counsel for the respondent number 3. And who is for respondent number 1? Mr. P. Soikia, learned counsel for the respondent number 1. Argument concluded. Order reserved.
I am for true, my lord.
So item number 8,
Obliged.
Yes.
May I please lord. Lord, in this case, my lord, earlier, my lord, department took time, my lord, to file affidavit. And there is a specific query put by this on court, my lord, on 17/3, my lord. They have not responded till date. This 54, my lord, is the last communication, my lord, by the department.
Okay, who is Mr. Soikia? You are for respondent number 1, yeah? Who is for respondent number 2, 3, 4, and 5?
My lord, secondary department will appear in this matter.
Pardon?
Secondary department will appear in it. They can appear for all the respondents. Director, commissioner, and inspector.
District committee.
Secondary.
4 and 5 district.
Heard Mr. Arale, learned counsel for the petitioner,
State level committee was.
and none appears for the respondent on call.
District level.
Office note dated 16/9/2024 indicates that
District level.
no counter affidavit has been filed.
My lord,
By the
district-
respondent.
district level committee, I can appear. My lord.
Pardon?
District level committee, I can appear.
You.
My lord.
Respondent number 5.
District level committee, yes, respondent number 5.
My lord. I can appear.
Respondent number how about Mr. Isokia, learned counsel for the respondent number 5 present. None appears for the rest of the respondents. And no counter affidavit has been filed in view of office note dated so and so. Recess will list the matter on immediately after reopening of the vacation. In the event of subsequent non-appearance and not filing of the counter affidavit, appropriate orders shall follow.
My lord, GA may be reflected in the cause list matter.
Pardon?
GA may be reflected in the cause list matter.
Who?
GA, government. matter. GA Assam may be reflected in the cause list.
Mr. Soikia, learned counsel for the respondent number
Five.
six,
Five.
six or
Five.
five,
Five.
respondent number 5 submits that the government of Assam in a government advocate, name of government advocate may be reflected in the court list. The assessor will do the needful in this regard.
Item numbers
Must.
9 to 13.
Your lordship, kindly see your lordship's order, last order. It is dated, my lord, 2/9/24. And in the meantime, your lordship, what will be taking over?
Yes, so who is for the respondent number 3?
Lordship, in this case, the affidavit is otherwise ready, we just have to file it, Lordship. We have to send it for vetting. In the case of WPC 4278 of 2021,
What about
affidavit is ready, we just have to send it for vetting.
So when you will be able to file it?
Lordship, may list after vacations, we'll file it by this week or next
Anyway, my
week.
lord, they will file it after vacation. I have no point. But your lordship, kindly see one affidavit that has been filed by the university the other day. It has clearly said, my lord, in that affidavit, in paragraph 4, that in view of above, the deponent university is interested to provide affiliation. This case of affiliation, my lord. Provide affiliation to the pharmacy institution subject to approval by the government, and in event will take all the required steps towards the direction. This was filed, my lord, on 2/9/20.
24.
Yes.
Yes.
So this is a very short one. In paragraph 1, they have indicated that the connected writ petition was filed with the writ petition praying for a direction from the Honorable High Court considering to consider affiliation of the petitioner's college in terms of the letter dated 22/4/2019 as well as satisfactory inspection. So if your lordship your lordship, I have only one prayer, my lord. Let them take time. There is provision in the Act, my lord, PCI Act, to give provisional affiliation. And we have already got affiliation for up to 2024. But our problem is that now this session for examination and new admission has come. So if you do not get the affiliation temporary for say 6 months time, one session will be, our students will be suffered, and in one session, we will not be able to give new admission. For that, my lord, your lordship will kindly go to page number 32 of my petition.
30?
32, my lord.
Yes.
This was the later, my lord, in 2019, it started to give the NOC for affiliation. It is written by addressed to the Director, Medical Education. In continuation to this department, earlier letter so and so, requesting submission of the inspection report on feasibility of starting defarm courses by constituting a committee. I am directed to enclose a copy of the another application dated so and so, requesting for NOC for diploma pharmacy, Bachelor of Pharmacy courses. Next paragraph, my lord. It is required that an inspection may be carried out by the committee mentioned in the aforesaid department later dated so and so. The committee, so that was the, and that thereafter, my lord, the committee has given the report. At page, my lord, 44. It is from the Director Medical Education. After inspection, he has given this. Madam, with reference to subject cited above, I have the honor to submit here with the inspection report submitted by the inspection committee constituted by the Director so and so, in respect of Hamak College of Pharmacy, Dental, Medical, Nagaon, regarding D-Farm and D-Farm courses. Then, my lord, one, the starting of the D-Farm and D-Farm courses of Hamak Pharmacy, Dental Science, Nagaon is essential for producing more numbers of degree diploma holders in pharmacy sector. The said institution at present meets the requirement norms as laid down by PCI, and therefore NOC may perhaps be issued. So the government does not want to give it. They have made so many correspondences, and last, my lord, your lordship will see an order dated 12/2/24. Before your lordship passed that order, this was the order. 12/2/2024. Honorable Justice Unni Kishan. Well, 2024. Yes, Headmaster B. Gogoi, Learned Dissenting Counsel for the Health and Family Welfare Department in terms of the earlier direction passed and produced report for Srimantra Hankodu University of Health and Iman in the provisions of the said act demand. The health sciences also includes within its whole the pharmacy education. On the next day, fixed, Mr. Gogoi, Learned Counsel, Standing Counsel for the Health and Family Welfare Cell, received written instruction from the department authorities as to the extent of power of government to withhold NOC to an institution which has been granted provisional recognition by the Pharmacy Council of India. The relevant provisions of the Pharmacy Act, which empowers government to withhold the NOC, as well as the provisions required issuance of NOC by the government, shall also be made known. Mr. Gogoi, Learned Counsel for the Health and Family Welfare shall also receive instruction with regards to the compliance of the provisions of section 12(2) of the Pharmacy Act 1948 by Srimantra Hankodu. Now, my lord.
Pursuant to this order, my lord, I've got the instruction that I
Yes,
already
my lord.
furnished it.
I
And my
will-
lord,
will
in fact,
get-
my lord, today I have prepared the affidavit. I mailed it to both the authorities, Sankatam University as well as the my lord, health department. Probably by 1 or 2 o'clock, my lord, I will get the affidavit, signed affidavit, and I can file it today itself. I have sent it, my lord. And that is the instruction, my lord. Regarding that two specific query, my lord, I have got the instruction. I want to put it in the form and affidavit. And it will be filed today. I can assure that.
Anyway, my lord, that will be considered at the time of hearing,
Fine.
when your lordship will file. We'll file our reply to that petition.
Then, my lord, let me file the affidavit today itself. Lordship will fix a date, my lord, for final disposal. Because what has happened is, my lord, during the pendency of the writ petition, government has taken a policy decision that all pharmacy education, the institute whoever want to have a NOC as well as, my lord, other permission for opening a, my lord, D Pharm or B Pharm course, my lord, such institution will have to proceed through the Sankatam University, not under the ASTU. Petitioner has applied before ASTU, Assam Science and Technology University. Since, my lord, this pharmacy education relates to medical science, my lord, so government has taken a decision that it is the Sankatam University of Health Science who will be the eligible university for granting, my lord, necessary affiliation for opening the colleges or schools. So now, due to the change of policy, the Science and Technology University before whom the petitioner applied, they are not in a position to give any affiliation to the petitioner's institute.
Anyway, my lord.
So that's the issue, my lord. Now, until and unless that
That
policy is
issue,
put to
I will
challenge,
answer
it has
that
not been put to
issue
challenge, my lord.
by a Supreme Court judgment. Your lordship will go.
My lord, without
go
that
back ahead.
challenge to the policy, how can, my lord, by
Policy, yes,
passing
my
that, my lord?
This Supreme Court judgment has said state has no power to make any policy against NSE. But that is a central act. So central act cannot be dissolved by.
that part
So
will be
your lordship
decided
will
at the hearing.
judge it by this affidavit.
If lordship is taking up for hearing, my lord, in that case, the advocate general will appear in this particular case because there is a policy decision. And it has not been
No,
put to
no,
challenge.
anyway,
On the
I am
maintainability
not-
point, my
not-
lord, I have already filed.
Only I have shown the provision, particular page 5, that red mark, my lord, page 5. Page 1, my lord, your lordship will see what was the background. These present appeals are directed against the judgment and order passed by the High Court of Jurisdiction in Bombay on such and such and such. Read petition number so-and-so of so-and-so has been filed by so-and-so Maharashtra Pradesh. Considering the settling direction for order, a petition was filed for direction or order requesting and setting aside the order dated December 28, 2024, passed by the state of Maharashtra, by which the petitioner was informed that the state of Maharashtra has taken a policy decision not to grant no objection certificate, NOC in short, to any institution for starting B.A. college for the academic year so-and-so. It was also decided to communicate the state policy decision to the Maharashtra University, stating that necessary will arise in the next year. Application for the instruction would be considered at that time. A decision was also taken. A decision was also taken to bring into the notice of the National Council for Teachers Education, NCTE, that in the state of Maharashtra, there is no need for new B.Ed training, empower the NCT to not to directly consider any application for the grant of permission to start B.Ed colleges. In spite of the aforesaid policy decision by the state of Maharashtra, the NCT granted permission to petitioners institutions. The state hence challenged the said action by filing the petition. Then your lordship will go what that has been held in that particular writ petition, my lord. At page, my lord, that's page 5, my lord, that red mark next one. Red flag, my lord. It is 5 of 34. Your lordship
Yes.
got it? That the decision that has been taken by the Maharashtra Bombay High Court, my lord. Page 5 of 34.
Got it.
Got it, my lord, yes. Second, first paragraph. The High Court held that in the light of the relevant provisions of the Act as interpreted by this court in various decisions, the appropriate authority to take decisions regarding opening a college was NCET, and neither the state government nor the university can act contrary to the decision of the NCET. According to the High Court, under the Act, the only authority which could take a decision regarding opening of a new B.Ed college or increase in the intake policy of NCT, and such decision cannot be ignored either by the state authority or by the university. So far as the functions of the state government was concerned, the High Court observed that it was the nature of the supply of necessary data and materials to the enable NCT to undertake the process of coming to an appropriate decision, but the state had no power to decide that it had taken a policy decision not to grant permission to open a new B.Ed college for a particular particular period. Such decision was not in accordance with the provisions of the Act, nor in accordance with law laid down by this court. Then few lines behind my lord, it was therefore not open to the university to take any action overlooking the decisions of the NCT and relying on a decision of the state government. So this has been held in that particular, and that has been upheld by the Supreme Court. Your lordship will file last.
Mr. Buragoy,
Anyway, my lord. Yes.
let them file their affidavit.
Yes, my lord.
We will hear the matter on next day. We will fix a short date.
Why immediately after vacation on a hearing?
No,
level?
My lord, only one pair, my lord. It has, the petition has been filed in 2021.
Hmm.
And the instruction that is sought by this Honorable High Court in February. March, April, May, June, July, August, now September. 7 months has gone. So my anxiety is that there is the next session, our students will suffer. So I will pray your lordship and
when the
request
next
my
session start,
friend
please let me
to
inform
fix
them.
it before vacation. That is all.
When the next session will start?
Yeah.
July.
Next July.
So I am praying for
No, no.
October. I am not praying for sometime in 2025.
Admission, for admission, it is.
Okay, in the month of October. we
Anyway,
will
my
see.
lord, if your lordship files, I mean.
No, I will file it, my lord. I'm
and,
making an undertaking, my lord. It will be filed. I have sent it today itself, my lord.
Before vacation, it is not possible
Yes, my lord.
because a lot of matters have already been fixed.
Anyway, my lord,
Immediately after
your
reopening.
lordship will pass the order according to convenience of your lordship.
Heard Mr. A.C. Buragoy, learned single counsel assisted by Miss. Learned
Malina.
counsel for the petitioner
Tunupati.
and Mr. D. Gogoi,
Health department, my lord.
learned
Standing
counsel
counsel
for the respondent number.
My lord,
Three.
no, my lord. I pay for a government, my lord. 3 and 4.
Respondent number 3 and 4.
Okay.
And Mr.
Three
T. Gogoi,
My lord, I'm for respondent number 2.
respondent number 2.
Assam Science and Technology.
Respondent number 2. Mr. Gogoi submits that. No, Mr. Gogoi, learned counsel for the respondent number 3 and 4 submits that his affidavit is ready,
My lord.
and during the course of the day he will file the same.
Lordship.
In view of the submission of learned advocates of both the parties, it is provided that SSL is the matter. Data card detail.
29th October,
My on a hearing that Thursday,
Tuesday, 29th October.
my lord.
On that day, an endeavor will be made to dispose, finally hear and dispose of the matter.
Oblige, my lord.
Pardon?
But come this.
10, 11.
Let it remain together, madam. On that day, lordship will decide whether to segregate or.
This will remain with the main petition. Okay, okay. Okay, yeah.
Lordship was 29, 29.
29th October.
My lord, I'm obliged.
Item number 14.
Oblige, my lord.
May I please interrupt?
Yes.
My lord, actually an affidavit is required, my lord. That affidavit is not coming till date, my lord.
Affidavit not filed.
Not filed, my lord. My lord, matter relates to my lordship is well aware, my lord, that the Madrasa institution in the state of Assam has already been abolished and it has been transformed into schools, my lord. Now the students studying in the madrasas, my lord, they have been left unattended and neither they can go for the admission in the schools as well as alternate institutions are not there. So some of the students are now before my lord, that what policy the government has taken for these categories of students, my lord, that is not clear from the SOP, my lord. That's why an affidavit is required, my lord.
Okay, madam, you are appearing for the state?
Waiting for the secondary department, your lordship.
No, voice for respondent number 1, 2, and 4.
I'm for 1, 2, 3, your lordship.
1, 2, 3.
For my lord, senior counsel, Mr. T.C. Chutia appears, my lord.
Who?
Mr. T.C. Chutia, my lord, for the respondent for Seva, my lord.
Acha.
But my lord, mainly affidavit is required from the secondary education department.
Secondary education, education department is respondent number 3.
Yes, my lord, 1, 2, and 3 all are, my lord.
So when you are going to file your affidavit?
Lordship, after the vacations, your lordship.
Heard Mr. A.R. Bhuya, learned counsel for the petitioner, and Madam Teran Pil, learned counsel for the standing counsel for the respondent number 1, 2, and 3. None appears for the respondent number 4. Ms. Teran Pil submits that after reopening of the vacation, she will file the affidavit in opposition on behalf of respondent number 1, 2, and 3. Here is accordingly allowed. Races shall list the matter on
4th November.
Mal, obliged.
15 and 16.
But in this finally there is the last order, my lord.
Well, in this case, I'm waiting further 2 weeks time to file affidavit.
further 2 weeks.
Last listed on 14/12/2023, my lord. December, my lord, 23. Till that, my lord, no affidavit has been filed, my lord.
So, madam, you have been given sufficient opportunity to file the affidavit in opposition.
Right. That is the last one's file. I will file my.
Heard Mr. Padgiri, learned counsel for the petitioner, and Madam
S. Sutia,
S. Sutia, learned counsel for the standing counsel for the respondent number.
elementary education.
I am for respondent number 4, my lord.
For respondent number
I'm for 4, my lord, respondent number 4, NCT.
6, 7, 8.
6, 7, 8, 9, and 10.
10.
6, 7, 8, 9, and 10. And Mr.
T. Sheikh, my lord, on behalf of Mr. I. Anam, standing counsel NCT, my lord.
NCT.
Yes, my lord.
And Mr. Soikia,
For 5.
respondent number 5. And for rest of the respondents, 1, 2, 3.
2, my lord, finance. 1, my lord, also represent my lord, pending of the elementary. My lord. 1.
Ms. Sotia, learned counsel for the respondent number 6, 7, 8, 9, and 10. Price for granting her 2 weeks time to file the counter affidavit. Where is allowed. How it is made clear that no further chance will be granted to the learned counsel to file the affidavit in this. List the matter after vacation.
Item 17.
Right, please, lordship. This is a family pension matter, my lord. Petitioner is the second wife, my lord. My name is in the nomination in the service book, my lord. And my lord, in the data caption in the annexure 2 page 18, my lord. This is name of the spouse, Nurjahan Begum. Nominee is there, my lord. But family pension has not been disbursed to me.
Lordship, this is in the matter agitated in this petition is already addressed by the full bench of this honorable court, Lordship. I have got the judgment.
But mostly sorry, my lord, after 4 minutes of equal share, my lord, they are entitled. But in this case, my lord.
Mr. Dasa, you are appearing for?
I'm for the private respondent, Lordship, first wife.
And for the rest of
concerned
the
department
respondents?
is elementary.
Second wife is the nominee, my lord, in the circuit.
But this will be guided by this, as on today, this is the law, my lord, the full bench judgment. Paragraph 19, it's a relevant paragraph, Lordship. Paragraph 19, 20, 21, 22, 23, Lordship. At page number 10. May I read, Lordship, please? May I read, Lordship?
Yes.
Relevant paragraph, Lordship. Paragraph 19, Lordship. A conjoint reading of note 1 to rule 143.2 and rule 143 of the pension rules 1969 makes it explicit and unambiguous that family pension would be payable to the eldest surviving widow in the event of there being 2 or more widows, and further that even if there are minor children who may also be entitled to the benefits of a family pension, the pension would be paid only one member of the family at that time, at the same time. For the first instance, it would be paid to the eldest of the surviving widow, and thereafter on her death to the next surviving widow, if any, and in its absence, the minor children. Then Lordship, at paragraph 20, as a corollary to the provisions of rule 143.3, the pension rules of 1969, note 1 to rule 143.2 would have to be read to mean that the family pension would be payable to the eldest of the surviving widows in the event of there are 2 or more widows, and thereafter on her death, it would be payable to the next surviving widow, if any, thereafter to the minor children, if any occasions arises. Paragraph 21, Lordship. In the circumstances, the concept of the validity and acceptability of a second marriage where the parties are governed by the Mohammedan law and the consequential entitlement to the benefits of a family pension, and the concept to whom the family pension would be payable under the pension rules of 1969 are held to be 2 separate and unrelated concepts, and the implication of the concept of the validity and acceptability of a second marriage or further marriages where the parties are governed by the Mohammedan law would have no bearing on the concept to whom the family pension is payable under the Pension Rules 1969. It is held that irrespective of the validity and acceptability of the second marriage or further marriages, where the parties are governed by the Mohammedan law, the family pension under the Rule 143 of the Pension Rules 1969 would be payable to the eldest surviving widow, which would also be applicable for a family pension where the parties are governed by the principles of Mohammedan law, and where there may be a validity and acceptability of the second wife or further wives in respect of a deceased Mohammedan employee. Paragraph 22. We further hold that the family pension being payable to the eldest of the surviving widow or wife would not mean that the entire family pension so payable would be the personal property of the eldest surviving widow or wife and the family pension so payable would be held by the eldest of the surviving widow or wife as a trustee for all such other persons who are entitled to the benefits of the family pension in terms of the Rule 143 of the Family Pension Rule 1969. Paragraph 23. We also provide that in the event of any such persons who are entitled to the benefits of family pension in terms of the Rule 143 of the Family Pension Rules 1969, including the second or further wives, in a case where the parties are governed by Mohammedan law, are not appropriately maintained by the eldest of the surviving widow or wife to whom the pension will be paid, the remedy thereof would be to make a claim for maintenance in the appropriate forum under the law, not a claim for a payment of a family pension by the state authorities directly to such persons. But however, if in a given case, the state authorities or on their own volition are of the view that under an acceptable circumstance, the authorities are agreeable to require to pay the pension separately to any such member of a family of a deceased employee, this judgment may not be constituted as the absolute bar on such separate payment. This paragraph 23 is very clear. It would go to the eldest surviving wife and she would be the trustee of the family pension. And if it is not appropriately divided amongst the entitled family pension holder, then they can make a claim. So under the appropriate forum.
You are for private respondent
Yes,
number
private respondent number 9 is the first wife.
9.
Eldest surviving wife.
Yes, for rest of the respondents. Respondent number
1, 2, 5. Education, elementary education.
1, 2, and 5.
1, 2, 5, 6, and 7.
1, 2, 5.
6 and 7.
So what is your submission?
My instruction is, my lord, they have not submitted their relevant documents, my lord, before the authority, my lord. So therefore, we could not process, my lord.
The first wife, my lord, since long time she is separately staying. That is why, my lord, the second wife is nominee entry in the her name is entry in the service book and nomination paper, my lord. That as such, my lord, the petitioner, my lord, maybe second wife, but all the benefits are recorded are as a like as first wife, my lord. The first wife, since long time she is separate, and also she's doing one Anganwadi worker also, and she has the sufficient income to maintain herself. But the second wife has absolutely nothing, my lord, to maintain herself to have life. That is why, my lord, as per provision of Rule 137, Family Pension Rule 1954, my lord, the question whether a second wife is entitled to have family pension during the lifetime of the first wife.
You are, Mr. Islam, you are reading the rule?
Rule 137.
137.
Page 154.
Rule 137. 37.
137, rule
Yes.
137. Family pension, 1954. The question whether a second wife is entitled to have family pension during the lifetime of the first wife held that the family claim of the read petitioner is beyond the scope of consideration, having been considered the rules provided in 136, 137, 143, and in the Assam Civil Service Conduct Rules 1968. Muhammad Fazila Begum, alias Fazlia Begum versus State of Assam, 2009, Volume 3, GLR 2105.
Yes, any other point? No. Mr. B. Islam, learned counsel for the petitioner, and Mr. D. does learned counsel for the respondent number 9. You have been implemented later on.
Yes. But
Okay.
evidently I'm the eldest surviving wife.
Whether amended cause title was filed.
It was already there, Lordship. In my petition, already my name, respondent number 9 is there.
Main petition.
Order dated 12/9/22.
Order dated
12/9/22. The order issuing notice in the case laws. Order issuing notice in this present case laws. 12/9/22 laws.
But this amended cause title has not been submitted.
But in the order, Lordship, the petitioner to take steps on respondent number 9, it is reflected, Lordship. 12/9/22, Lordship. Lordship, kindly query. 12/9/22.
No, order is there.
Yes, Lordship. But in my petition, I am already there, Lordship.
Respondent number 9 and Madam Sophia, learned counsel for the respondent number 1, 2, 5, 6, and 7. Argument concluded, order reserved.
I'm different.
It will get.
I would place on citation mallet after supplement.
Pardon?
I will supply one citation mallet regarding.
Okay, you can furnish it to court master.
Okay.
Item 18.
Actually, this application is filed by APDCL. They agreed by the order dated 26/9/2023. We are directed to pay interest on compensation which was already decreased. The respondent lordship has filed a suit claiming a compensation on account of death of her husband. The lordship will find the plaint starts from page 19. Runs up to page
60.
Page number?
Page number 19 is the claim, Lordship.
Yes.
Yes. And your Lordship will find the judgment and decree passed by the learned court below at page 61. Page 61. Page number 65 is the relevant portion. Paragraph number 4. The issue number 5 regarding the entitlement of compensation by the plaintiff cannot be brushed aside as the plaintiff claimed of an amount of rupees 12 lakh only as compensation appears to be reasonable in view of the entire facts of the records above, the background and history of the plaintiff's family, misfortune and their ancillary family future. In fact, the plaintiff is in previous grief of misfortune after the death of her husband. The issue number 5 is determined in affirmative. In determining the issue number 6, the court is inclined not to grant any other relief in addition to the decree the court is determining to grant. So, an compensation of rupees 12 lakh was decreed. Thereafter, Lordship, APDCL filed first appeal, which was dismissed, and subsequently second appeal was filed before this honorable court. This honorable court in RSA number 103 of 2014 at page number 670 starts from page number 70 to 71, directed APDCL to file an application because the suit was the decree was passed ex parte, because after filing of the written statement, APDCL counsel for APDCL did not appear. So the argument was heard ex parte, and therefore in the RSA we were directed to file an application under Order 9. Order 9 Rule 30 for setting aside the ex parte order. Thereafter, we did not file in that application as part of the judgment. We paid the compensation amount, 12 lakh rupees. On 7/11/2022, we paid the compensation amount. In the meantime, your Lordship will find at page 73, a petition is filed under section 47 CPC claiming interest on the compensation amount which was decreed. The decree is absolutely silent regarding the interest. It has only paid the compensation amount which we have already deposited. Petition number 165, 2023. Your Lordship will find at page 73.
Yes.
The contention of the respondent was that in that petition is that we paid the compensation amount at a belated stage. There was a delay on our part, so they are entitled for interest on the compensation amount. Thereafter, Lordship, we filed our objection.
Well, what is the order?
Your Lordship will find the order at page 94. It starts from 94. Runs up to page 103. 102 is the relevant portion. Based on the judgments passed in Sundar and Gurpreet Singh of the Honorable Apex Court, the learned court below directed us to pay interest and compensation, whereas the decree is absolutely silent regarding interest. The decree is only with regard to compensation. So here the executing court, Lordship, travel beyond the decree, which is not permissible at law.
So what is the finding of the court?
The finding of the court, your Lordship will find at page
97, 96.
96.
From 96 to notes.
96. I have gone through the above decisions. Your Lordship will find the 3 decisions are also reflected in the orders. Changa Singh and another versus Union of India. Gurpreet Singh versus Union of India. Sundar versus Union of India.
Yes.
In the case of Changa Singh, Honorable Supreme Court relied on the ratio laid down by that court. In the case of Gurpreet Singh versus Union of India, in the case of Gurpreet Singh versus Union of India, the Honorable Court observed in para number 54 that one other question also was sought to be raised and answered by this bench, though not referred to it, considering that the question arises in various cases pending in courts all over the country. We permitted the counsel to address us on that question. That
Question is whether in the light of the decision in Sundar, the awardee decree holder would be entitled to claim interest on solatium in execution, though it is not specifically granted by the decree. It is well settled that an execution court cannot go behind the decree if therefore the claim for interest on solatium had been made and the same has been negatived either expressly or by necessary implication by the judgment or decree of the reference court or of the appellate court. The execution court will have necessarily to reject the claim for interest on solatium based on Sundar on the ground that the execution court cannot go behind the decree. But if the award of the reference court or that of the appellate court does not specifically refer to the question of interest on solatium, or in cases where claim had not been made and rejected either expressly or impliedly by the reference court or the appellate court and merely interest on compensation is awarded, then it would be open to the execution court to apply the ratio of Sundar and say that the compensation awarded includes solatium, and in such an event, interest on the amount could be directed to be deposited in execution. Otherwise not. We also clarify that such interest on solatium can be claimed only in pending executions and not in closed executions, and the execution court will be entitled to permit its recovery from the date of the judgment in Sundar and not for any prior period. In the case of Changa Singh, Honorable Court directed the respondent to make the payment of interest on solatium as per the law laid down in Gurpreet Singh within a period of 3 months from the date of order. In the case of Sundar versus Union of India, Honorable Supreme Court observed in para number 4 that that decision was followed by 2-judge bench of this court in Perry and Perry Kearney Roberts Limited versus State of Kerala. In the concluding part of that decision, said as follows: therefore, we have no hesitation to hold that Section 25(3) contemplates payment of interest on solatium to recompensate the owner of the land for loss of user of the land from the date of taking possession till date of payment into court. The word compensation has been advisedly used by the legislature. Accordingly, we hold that appellant is entitled to interest on solatium.
So what is the ultimate finding of the court? But these decisions perhaps delivered in case of land acquisition cases.
In all the cases are related to land acquisition cases. Not a single judgment I have
The
found.
question before the court was whether interest can be granted on solatium.
Yes.
But this is not the case of solatium.
Yes.
So whether interest can be granted here?
No, not at all. Because the decree is absolutely silent regarding interest. The decree has only said about payment of compensation. The executing court traveled beyond the decree.
Oh, we'll resume after 5 minutes.
Not sure.
Yes, sir.
That although the executing court did not award interest on the principal amount of rupees 12 lakh, the principle of equity and justice demands that the decree holder should be awarded interest on the said principal amount on solatium ground. There is no bar in filing such a petition in the execution case, as the decree holder is the rightful claimant of the interest accrued upon the principal amount. The execution case cannot be said to be disposed of, as the decree holder is yet to receive the interest on the principal amount. There is no requirement to file a separate case for the recovery of the interest on the principal amount, and this executing court is fully empowered to award interest on the compensation amount already received by the decree holder. Situated thus, petition filed by the decree holder is hereby allowed in judgment debtors are hereby directed to pay an interest at the rate of 9% per annum from the date of judgment.
Yes, madam.
Yes, madam. But solatium means it was pain, will suffering. For suffering, we lost our close relatives. My husband was died in 2001. The compensation award granted me on 2022. The long after 21 years, after long 21 years. In between, they came to this honorable court, high court also. There is also will suffer. Then in 2001 to till 2022, they did not pay a single amount to us. And we suffered for last 20 years. And then solatium, what is solatium? Solatium is something given to compensation for inconvenience, loss, injury, or the like of compensations. Then there is an also question of solatium.
The judgments, the trial court, the executing court had relied upon relates to solatium in granting in case of land acquisition cases.
Yes, my lord.
So whether the same ratio can be applied in this case also,
Yes,
and that too by the executing court. Can the executing court go beyond the decree?
Decree. But in this land liquidation act, this is also the suffer by these agricultural people. Then they will suffer. I lost my personal suffering. I lost my husband. Last 20 years, I only being a mother. I have 4 children. I have 4 children are growing up already. When my husband was already died, he was on my elder son was only 1 year. When I get the compensation, he was only completed her master degree. Then last 20 years we are suffering for it. Law for all, I think, my lord, not only for the Law Acquisition Act, but this one, because this one also in the page number 95, this was already said that the interest on the compensation amount cannot be served from the compensation amount and decrease the must enter to get the same. Such cannot be deprived of the interest on the principal amount merely on the ground that there is no specific direction of the execution code in this regard. Yes, already my friend opposite already read out these portions. And this was and in page number this land acquisition case also, this one Sundar versus this one after 19/9/2001 execution code beyond the decree, this one which one said by the this our honorable court, and the case was already Sundar versus Union of India court. This was already suffered that we can get benefit.
No, in respect of land acquisition cases, it is settled. But the question is, can we apply those principles in this case or not? That
Yes,
is
solution means so you are suffering for loss. We are our loss. That is main thing, my lord. There's already then definitions that solution is something is given to compensation for inconvenience, loss, injury, or the like compensations. There is also question of solution for the loss of close relatives also. What is solution? Solution is main thing what? Only the
okay. Heard Mr. Arbora, learned counsel for the petitioner, and Madam Madhi, learned counsel for the respondent. Argument concluded, order reserved.
Item 19.
Allow the petition.
Pardon?
Lordship is allowed the petition.
No, reserve the order.
May I please this judgment of the apex court, Lordship?
Pardon?
May I please this judgment of the apex court?
Item 19.
Because otherwise also Lordship is very correct, because it's a statutory concept under the either under the Land Acquisition Act or under the Right to Fair Competition.
Solution is what is meaning by solution? Solution is the loss or the suffering. Suffering not only suffered by the this one also.
Next item.
All right.
Hello, yes.
You are for respondent.
Lordship.
None appears for the petitioner on call. How about Miss? Your good name, please.
N. Kakoti.
N. Kakote, learned counsel for the respondent present. Recess shall reach the matter immediately after vacation.
Item 20.
Hello.
Maybe, madam. This is an appeal by the claimant for enhancement against the award passed by the learned tribunal.
What is the ground?
Ground, my lord, we have adduced evidence to the effect that the claimant they used to earn rupees 12,500 per month, but the learned the tribunal granted only 7,000.
Whether you have adduced any documentary proof?
No. Documentary proof I did not give, but we have stated on oath that I was a commercial driver and I used to drive vehicle at Nalbari bus stand. Therefore, I used to, and further I have stated that I used to earn rupees 500 to 600 per day working for 25 days for a month. So that comes to 12,500. That is the first ground I have taken. Secondly, the person received injury on his head, then two sides of his face and his legs. As a result of which he was hospitalized for 2.5 months.
So this is injury case.
Yes, injury case. But what happened, my lord? Under the heading pain, shock, and suffering, only 10,000 rupees was granted. And regarding during this hospitalized period and thereafter,
Is there any disability?
no,
No
there is no
disability.
disability. But there is evidence on record that he was hospitalized for 2.5 months. The discharge summary was of the hospital was on record.
Heard Mr. Bhattacharya, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and order dated 18/7/2024, passed by the learned counsel for the passed by the learned member MSCT number 3 Kamrup M Guwahati in MSC case number 566 of 2017. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the respondent insurance company to pay a sum of rupees 6,66,805 rupees, being the compensation to the claimant, to the appellant. Mr. Bhattacharya, learned counsel for the appellant, submits that this appeal is preferred for enhancement of the awarded amount on the ground that the learned tribunal, while assessing the compensation, has fixed the monthly income of the claimant at rupees
7,500.
7,500. But the same ought to have been 12,500. As the claimant was working as a driver of a commercial vehicle and he has been paid a sum of rupees 500 per day, and the same, if the same is counted for 24 days, then it would come to a sum of rupees 12,500. And what is the other ground?
Other ground regarding pain shock under the heading pain, shock, and suffering, only 10,000 rupees was granted.
Mr. Bhattacharya further submits that the learned tribunal in the head pain, shock, suffering, and mental agony had awarded only a sum of rupees 15,000, which is grossly inadequate in view of the fact that he was hospitalized for how many days?
So 2 months, 2.5 months.
For 2.5 months. Be that as it may, at this instance, admit the appeal. Issue notice to the respondents, returnable in 4 weeks, that be taken by registered post with ADA and also by result process within a week from today. Recess will call for the record from the learned tribunal. List the matter after 4 weeks.
Much obliged.
21.
And please, your lordship. Because in this case, there's a collision between two vehicles. And it's appeal against the finding of the learned member that it occurred due to there's a negligence of only one vehicle that was incurred by the.
So whether any issue on the composite negligence was framed?
There's an issue also in this. Where is the alleged motor vehicle accident? Issue number 1, lordship. In page number 14 of the memo of it. Where the alleged motor vehicle accident had taken place on 22/3/2020 at about 1:45 AM at Bhutnath, DG Road near Bhutnath Police Point. under Bormuk Police Station, due to rash and negligent manner of driving on the part of the driver of the vehicle bearing registration number, so and so, that is pickup van.
No
That's
issue was framed on that count.
No, it is on this count, whether it has occurred due to the accident, rash and negligence of the pickup van. There is no doubt, the accident, the two vehicles were involved. I'm telling you the particular finding, it did not occur only due to the eye. It is a composite negligence. Drivers of both the vehicles has died. There is contradiction in witness when there are other analogous cases. In one analogous case that I have filed an appeal against that analogous case also. It has not come, but there are contradictions between the witnesses of the in both the cases. So it's a case of I'm just deposit 50% now because I'm pleading only for 50%, not a complete negligence of any one vehicle. In the middle of the night, Lordship, what happened was one vehicle was taking turn towards Butnat at 1:45 in the night. The other vehicle was coming from the other side, Bolero vehicle. And said both the vehicles had its headlights on. And there is even Lordship not correct. He is not picture is not come from either in this case or in the other case. This is the safest here.
Whether any police case was registered?
Both the vehicles liable for it.
Any police case was registered?
Yes, sir.
Search it submitted.
Search it submitted. Search it is also there.
Against which vehicle?
Against the vehicle insured by me.
Okay,
The
Headmaster.
circumstances and the facts and surrender case and also the eyewitness different in both the cases.
Or Samir Learned Counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 27/5/2024, passed by the learned member MSCT number 2 Kamrup and Guwahati in MSC case number 780 of 2020, filed under section 166 of the MB Act. It is to be noted here that by the impugned judgment and award dated so and so, the learned member MSCT Kamrup number 3, number 2, directed the appellant insurance company to pay a sum of rupees 11 lakhs. No, 15 lakhs 11,679.68 rupees. Peruse the memo of appeal and the grounds mentioned therein. Admit, issue notice to the respondents, returnable in 4 weeks, shall be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record from the learned member, MSCT number 2, Kamrup M. Guwahati. List the matter after 4 weeks. There is IA. 50% you have to deposit.
In case I am pleading for 50%.
IA dispose of.
22 obligation.
My lord reports, my learned friend was directed to take instructions whether I am entitled for incremental benefits from the date of my joining as per the last court's order and the approval of the director.
Your Lordship. Lordship may kindly turn to page number 14 of the writ petition, Lordship. Their prayer portion, Lordship. Roman 1. They are seeking a direction to the respondent number 4 to grant the benefit of the petitioner's past service for the purpose of computation of pensionary benefit and pension under the Assam Service Rule 1969. Lordship, they are already working. They are working still, Lordship. They are not retired. So Lordship can grant direction. Direction can given to them to grant the benefit of the pensionary benefit, Lordship. And on the other hand, Lordship, they are under their prayer is that to count their past services, to allow their past services. It is already done, Lordship.
No, on the other day you have produced one.
Yes, Lordship. I have instruction, Lordship.
As we are coming to all pension scheme lordship, GPF account is required.
When he was appointed?
My date of joining is, my lord, 5/9/1987.
5/9/1987.
Yes. The GPF account has been granted from that date. After the last order of this.
Page 58, annexure 11, it is reflected lordship.
So what other benefits you were entitled to?
That was what your lordship has directed my learned friend to seek instructions. That was the query, even though it is not reflected in the order, but was made quite clear.
As per all pension rule lordship, all the benefits. Lordship, may kindly have a look at the instruction I have submitted.
Where is the order of this court?
And the order starts at page 49. And the effective portion is at page 53 from para 5 onwards.
Page 50?
3. Para 6, your lordship will see page 53. As the issue for determination, I have already received due consideration of this court. The present writ petitions do not require reiteration on the same issue, save and except to hold that in consonance with judicial discipline, similar order is required to be passed in favor of the writ petitioners herein. Accordingly, the writ petition stands allowed by directing the state respondents to desist from acting on the undertaking given by the writ petitioners and to count the benefits of past services of all the petitioners for the purpose of pensionary benefits as per the provisions under the Assam Services Pension Rules 1969.
So thereafter, this order was passed.
Yes. Order is at page 56.
Yes, 56. Extending all the pensionary benefit to you.
Yes. But
And this GPF number is also allotted to you.
allotted. But
Then what other reliefs you were entitled to?
what I have been instructed is that they are silent on the payment of my incremental benefits from my date of joining. That is from my date of joining. Because from my date of joining, I'll be entitled to the increments now. I'm not asking for the salary.
No. Was there any direction to the that effect of this court?
Even though those words were not used, my lord, but this court has said so that I'm entitled to everything.
So this order was based on
Yes.
earlier decision of this court in WBC number 3730 of 2011.
Yes. Yes.
Where it is stated that service of the petitioners therein are to be counted as per the provision of Assam Service Pension Rule 1969, and the benefit of their past services should be counted for the purpose of computation of pensionary benefits as per Rule 1969.
So
on the basis of this order, the respondent authorities have passed this order dated 26 June 2023.
Thereafter, the accountant general has created
Allotted the GPF number. Yes.
from my date of joining.
Hmm.
Now, there is no effective order with regard to my incremental benefits from my date of joining, because they will finally come and join when I am entitled for pension.
No, in
commentary
this
there.
order, there is no indication about incremental benefit.
Yes. So if the director simply revisits his order and grants me that benefit, one particular simple order.
No, how can we direct them to revisit this order? How?
Because of
Because this is not a review petition.
it's not a review petition.
Then
But the aspect regarding my incremental benefits, the director.
No, Lordship, PR is also for direction to grant the past services, Lordship.
That falls within those benefits. Sorry.
no direction in the writ petition number 3730 is only for the benefit of past service. Oh no, for the purpose of computation of pensionary benefit. Past service should be counted.
Yes.
So there is no indication that you will get your incremental benefit. Had it been there, definitely they would have granted. Hmm?
And if my learned friend is contesting, because she produced an instruction on the last day. If my learned friend is contesting, then let her file an affidavit.
Okay, I will file my affidavit, Lordship. No problem.
Okay.
Because I might be allowed to file a reply to the affidavit.
Heard Mr. P. Hortas, learned counsel for the petitioner, and Ms. Askur, learned counsel for the respondent.
Education Department, Lordship. 1, 3 and
For the respondent number 1, 3 and
1, 3, 1, 3, 4 and 6, 7. 1, 3, 4, 6, 7, Lordship.
1, 3, 4, 6, 7.
Lordship.
None appears for the rest of the respondents. Ms. Kumar submits that she has received instruction from the respondent authorities and she will file an affidavit within
After vacation, Lordship.
after the vacation. There is accordingly allowed recessal list after vacation.
23.
Okay.
Lordship, I have received the instructions and may be allowed to file our affidavit, Your Lordship. I have received it yesterday, Your Lordship.
Yes.
Let them file affidavit, my lord, then only will reply to that, my lord, because it is the indefinite continuation of suspension, my lord, without formal review.
Indefinite.
Indefinite, my lord. Now, what happened to the departmental proceeding, we do not know.
No, there is one judgment of the Supreme Court that
Yes,
it
I have
cannot
an
be.
ex, my lord. I have come with that, my lord. I want, let them file the affidavit. There is our court also, my lord, division bench also held, my lord. And Supreme Court also held that, my lord, indefinite period is not allowed. After expiry of the second, my lord, suspension period.
When he was suspended, you were suspended.
I was
First.
suspended, my lord, on February 27
27 to
or 24, my lord. Page 29.
It was initially for the period of 6 months.
No, 90 days.
90 days.
Incident that was extended.
Thereafter extended.
Thereafter, they have extended at page 44. After expiry period of 90 days.
That has been extended for the ongoing inquiries, Your Lordship. So the 90 days has been extended.
After expiry period of, my lord, 90 days. That cannot be, my lord. To that effect, my lord, our High Court also passed.
Whether proceeding has been drawn up.
That, my lord, they will tell that. Mere filing show cause or giving show cause, that is not.
I have received on that part, Your Lordship. As per report by the inspectors of school, Nagaon White, letter dated 19/9/2024, the bill for subsistence allowance in respect of the petitioner for the month of June, July, and August have been passed on 18/9/2024, Your Lordship.
We are not.
Okay, you file affidavit. Heard Mr. J. Borgonia, learned
Short date
counsel
be
for.
given, my lord.
Pardon?
A short date be given, my lord.
So that means anyway it will go after the vacation.
Need a lordship fix the date.
Ms. Dhiranti, learned counsel appearing for respondent number.
All respondents, Your
For
Lordship.
all the respondents submits that she has received instruction and she will be filing affidavit within a very short period. Here is accordingly allowed. recessal is the matter immediately after reopening of the vacation.
Lordship can fix the date, my lord, on 25th October.
Okay,
Okay.
20?
25th.
October.
Item 24.
My lord, petitioner is the senior most claimant to become the in-charge headmaster of Bongaigaon Vidyapit High School. Now the private respondent number 4 is junior to me so far receiving the graduate skill is concerned. But he has been given the charge of in-charge headmaster. And my lord, notice has been already served to all the parties. So my submission, lordship may kindly see page 20.
Whether counter affidavit is filed here?
Not filed, but
Not filed.
my prayer is this, my lord. When law says that I am the senior most teacher, so far graduate skill is concerned, and he received the graduate skill in the year 2013, and I received in 2010. That means 3 years to 3 months senior to him. Now, lordship, kindly see page 20. In persons of the Assam number so-and-so, dated so-and-so, Sri Parthapratim Ghosh, HS Pass was regularized as assistant teacher. Second, lordship, kindly see second para. On the other hand, Sri Kanailal Das, BSc Pass, holding the post of assistant teacher in the school against the post created originally by government letter number so-and-so and retained permanently dated so-and-so. Now, subject to the reversion, Sri Kanailal Das, who is working as assistant teacher, having the requisite qualification of BSc, is hereby allowed to hold the post of science graduate teacher, where Sri P.P. Ghosh is working and subsequently Sri P.P. Ghosh, age has passed, will hold the post of assistant teacher, where Sri Kanailal Das, BSc, first is working. Consequently, Sri Kanailal Das is allowed to draw the grade pay of science graduate teacher of so-and-so in the pay scale of so-and-so. This is, my lord, 30th July 2010. Now, lordship, kindly come to page 8, my lord. Page 8 it is there, but it page 9, operative portion, page 9, second para.
Page 9 is your writ petition.
Page 9, so first can listen top, my lord. His post was upgraded and he is the qualified second senior most teacher of Vidyapit High School, Bongaigaon nowadays. But Sri Raja Chatterjee has been appointed in the year 2013. And since then he has been getting the graduate skill. So my clear case is this, and whereas the petitioner is getting the graduate skill since 1/7/2010, more than 3 years senior. So I am in a better position to get the charge of the in-charge headmaster. Now, so for lordship may kindly see the Assam Secondary Education Provincialized Service Rules 2018, section 14 kindly see. Section 14.
Assam provincialized?
Assam Secondary Education Provincialized Schools Service Rule 2018. Section 14, proviso may be seen. Page 35 bottom. That should have seen. Yes, provided that the seniority of graduate teacher shall be determined from the
You
date
are referring to section?
14, 1/4. Page 35 bottom, his book.
Yes.
Provided that seniority of graduate teacher shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher. So, my lord, rule is very much clear that from the day of receiving respective graduate scale, so I received graduate scale on 1/7/2010 and he received graduate scale on in the year 2013, first appointment, his first appointment. But so for the appointment part is concerned, I am also more senior because my appointment originally was in the year 1993. 1993, and he got the appointment in the year 2013. But I got the graduate scale in the year 2010, and he got in 2013. 3 years, 2 months junior to me. So for graduate scale receiving is concerned. So when law is very much clear, he cannot be given the charge. By affidavit, they cannot improve their case because law is here. Law says seniority of the graduate teacher shall be counted from the day when they receive the graduate scale. So I received the graduate scale in 2010. So my lord, I filed petition before the authority. That lordship may kindly see is 28 and 29.
So, what is the role?
They have not done nothing, my lord. They have simply forwarded.
In respect of appointment of inserts principal. Inserts headmaster.
Since rational number 4 has been given in charge headmaster, not principal.
No, what the rule provides.
The seniority in respect of.
So the rule.
Yes. As per rule, my
Yes.
that assistant teacher who received the graduate skill earlier, he shall be.
Where it is provided.
It is section 14. Provided that the proviso part in top I am not reading because that is not so much relevant.
No, that is in respect of appointment of full-fledged headmaster. Regarding inserts headmaster, is there any
In-charge
rule?
headmaster, my lord, that is actually in-charge headmaster. There is no any such
Rule.
direct rule provides that, but no, it is the precedent being followed that the senior most graduate teacher, he will get the charge till the regular headmaster is appointed.
Where is that order?
Order, my lord, we were not provided order in respect of our level base, but it is in record perhaps because government advocate was directed to produce this, so it may be in record, my lord. It has been reflected also. Order dated 31/7/24 may be seen, my lord.
31?
31/7/24.
It is not available here. Yes, madam, are you appearing for the respondents? So where is that order?
I need to obtain the instructions in lordship, and the district elementary education should also be made a party, your lordship. As per the annexure 4, page number 20 regarding the order, your lordship.
Page number?
20, your lordship, of the writ petition. I appear for the secondary department, your lordship. So elementary department should also have made a party, your lordship.
No, whether
It is high school. It is high school now.
why high school? In case of high school, this elementary education is required to be implemented.
The order has been passed by the District Elementary Education Officer, Your Lordship. BTC 34 will explain me that.
Now it is the IS. Everything is done by IS. For instance,
This
kindly
order was passed a long back, 13th of July 2010.
Yes, Your Lordship.
well, we agitated the matter before the authorities.
Hmm.
But when I failed, then I have approached the Honorable High Court. And High Court Lordship would say page 29. Here, the IS has sent my letter, being satisfied. He has sent the letter, my objection in appointing the in-charge headmaster to respondent number 4. He said the submission of detailed report in connection with seniority of Sri Kanailal Das, S.A. Bongaigaon Vidyapith, with reference to the submission letter, I have the honor herewith submit the detailed report received from the headmaster of Bongaigaon Vidyapith High School in connection with seniority of Sri Kanailal Das, assistant teacher, for favor of your kind information and taking necessary action. So, my lord, this report has been brought, detailed report has been brought regarding seniority, and it is sent to the director by the IS. But director is keeping silence. So I have no alternative but to have to approach the honorable court, my lord. I am now humiliated because I am a senior teacher. And I am also not only BSc, I am also BT.
So, madam, you are representing a respondent number
1, 2, 3, Your Lordship.
1, 2, 3. So the school in which the petitioner is working is a high school.
Yes, Vidyapith High
So
School. Vidyapith High School.
elementary
instructions,
education has
Your
nothing
Lordship.
to do with his service.
I'll obtain the instructions, Your Lordship.
My lord, they cannot bring any instruction beyond the law, my lord. By affidavit, their Supreme Court judgment is there. By affidavit, case cannot be improved. When there is law is very much clear, seniority of the graduate teacher shall be counted from the day when they receive the.
No, Mr. Mahmood, that appointment order is not available on the record.
No, appointment letter is this private respondents. My appointment letter is available, page 14.
No. There's a appointment of the private respondent as the
That how can I get?
in-charge headmaster. That order is not available here.
That is what it was. May I see a record for a while, my lord?
Yes, you can see.
Because on that day it was said it should be kept in record. Second was already. Second, first.
Same thing.
No, the order sheet 9, order sheet 2, order 6. Yes, my lord. Kindly say that is very critical matter. That order sheet it reflects the be kept in record. I am reading as decided by this court earlier, Ms. D. Musahari, Landed Standing Council Secondary Education Department has produced an order dated 28 to 24 by which the respondent 4 has been allowed to act as headmaster in charge of Vidyapith High School. Order is there. So, but if the thing is not there, then it is serious matter.
কবে এইটো নাকি একবাৰ সুধো সুধো হচ্ছে না হয় নাকি এইটো অৰ্ডাৰ সেটৰ মাজত সোমাই আছিল
66 second election.
সেইটো হয় ন সেইটো হয় So what to do? Are you interested to file a affidavit in opposition?
Yes, Your Lordship, I'll file an affidavit. Your Lordship.
When?
After the vacations, Your Lordship.
My lord, I have objection because so many dates have gone, they have not filed, and I am humiliated before my juniors. I kindly consider this case. Admittedly, he is my junior, 13, and I got in 1993. And also, and my lord, if your lordship be pleased to hear that by affidavit case cannot be improved. There are
No, that's all right. It cannot be improved, but chance has to be given to them. Otherwise, we will stay this order.
That's my humble prayer, my lord. And respondent number 4, kindly see.
But in that case,
4 has not come. He has received the notice. Notice is served, but he has not come. What does it mean, my lord? He has been served.
Lordship, I have received an instructions here. It says that the petitioner did not complete 15 years of teaching experience as a graduate teacher, including the service rendered in the ME school, Your Lordship.
present petitioner.
Yes, Your Lordship.
Very surprising, my lord. He
Here it
has
says, Your Lordship.
lesser period than me. I have not completed. That is for the headmaster. Inside headmaster, it is a seniority only. He got appointment in there 2013, and he has been qualified. And I got appointment in there in 1993, graduated 2010.
15 years of teaching experience
Yes,
is required.
but
Your
what is
Lordship.
the private respondent's qualification? 15 years, he has got
But
a.
that will be the private respondents.
There is no reason.
For that.
There
Your
is no legal reason. It is maybe a.
Okay, we'll fix it before vacation. You file your affidavit. We'll see.
Before the vacations. Your
Heard
Lordship.
Mr. Mahmood, learned counsel for the petitioner, and Ms. Terampi, learned standing counsel for the respondents. Ms. Terampi submits that she has received the instruction and will be filing affidavit very soon. Considering all the facts and circumstances, Ms. Terampi is granted 10 days time
10
to
days.
file the affidavit. In the event of failing to file the affidavit within 10 days, the court will consider the interim pair made in this present petition. List on probably one date.
4th October, last day.
No, before vacation.
Before vacation, 4th October, before vacation.
Before vacation.
Obliged.
43, your lordship. So may I also for that? Wait, your lordship.
Will you inform the other side?
Yes, lord.
Your good name?
T go, your lordship.
Learned counsel appearing on behalf of Mr. A. Bhattacharya.
P Bhattacharya, your lordship. My name is Gary.
P. Bhattacharya, learned counsel for the petitioner. With consent from the other side, press for listening the matter after vacation. Fair lord.
Pending item number 3 for motion.
Wait, please, your lordship. It's the transfer of petition, my lord. My husband has filed a title suit for restitution in the court of the learned district judge Tejpur, my lord. My lord, I am residing at Lakhimpur, my lord. There were certain marital discord between the two of us. And if my lord may kindly for a moment come to annexure 1, my lord, at page 16. 16 is a typed copy. This has been continuing for a long time. I, Biplop Saha, dated, it was typed as, written as such, my lord. Page 16, my lord, annexure 1.
Okay, let notice go.
My lord, may I pray for a stay of the proceedings before the learned district judge Tejpur?
Heard Mr. PD. Dyer, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring title suit number 100 of 2024 from the Court of Learned District Judge Sonitpur at Tezpur to the Court of Learned District Judge Lakhimpur at North Lakhimpur, Assam. Mr. Nair, learned counsel for the petitioner submits that the petitioner is residing at her native place at Bipuria town, whereas the respondent has instituted the proceeding at Tezpur of Sonitpur district, and that it is difficult on the part of the petitioner to appear before the court at Tezpur, and therefore Mr. Nair has contended to allow this petition. But having considered the submission of Mr. Nair, learned counsel for the petitioner, and also considering the facts and circumstances on the record, it is provided that notice be issued to the respondent, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. And having considered the submission of Mr. Nair, learned counsel for the petitioner, till returnable that further proceeding of TS case number so is the state till returnable that.
Deep your pleasure.
Pending item number 4 for motion.
Your lordship, in this case, the engaged counsel, Mr. SP Roy, had to leave early as he was feeling unwell, your lordship. Can you take the matter next week, any date, lordship?
Next week may not be possible. We have already lot of matters. Anyway, on the pair being made by Mr.
J. Das.
J. Das, learned counsel for the petitioner, SSL is the matter after 1 week.
Pending item number 42.
File procedure. Date. This revision is filed by the state against an order of attachment, my lord. When a money decree was passed by the court in Hubli, subsequently, my lord, the new district of South Salmara Mankacha was created.
Now, the decree sought to be executed is against certain properties in the new district of South Salmara, Mankacher. Now, thereafter, my lord, in the execution case, my lord, it is another thing, my lord, whichever district it goes, ultimately, if it's a money decree, if the money decree remains, money has to be paid. But otherwise, my lord, if the lordship plans to page 62, an application was filed under section 39(4) of the Civil Procedure Code, my lord.
Page number?
Page 62, well, it's
Yes.
part of the imping order.
Hmm.
At the bottom, Lordship will find, so that being the factual aspect of the case, now let us see whether the petition filed by a judgment debtor under section 39(4) and 47(1) of CPC read with section 151 of the CPC is sustainable in law and facts. At the outset, let me lay down the aforesaid provision of law relied upon by the petitioner judgment debtor for better appreciation of the issue in hand. Now, 39 is quoted and 39(4) is important matter. Nothing in this section shall be deemed to authorize the court which passed a decree to execute such a decree against any person or property outside the local limits of its jurisdiction. Now, while deciding this, my lord, next page, page 64, Lordship kindly see, first 47 objection under section 47 was decided. Then page 64, my lord, bottom. Now, let me see whether the petition of the petitioner is sustainable under section 39(4) of the CPC. That plain reading of section 39(4) CPC reveals that it is a deeming provision, and the said provisions ordinarily debar the court from executing decree against any person or property outside the local limits of its jurisdiction. However, it is also pertinent to mention in this regard that the Supreme Court in the case of so-and-so had clarified the law relating to the aforesaid provision and categorically held that though section 39 does not authorize the court to execute the decree outside its jurisdiction, but it does not dilute the other provisions giving such power on compliance of the conditions stipulated in those provisions. Now, keeping in mind the aforesaid ratio of the almost apex court, if we see section 37 CPC explanation part, we will find that the provision of section 37 of the CPC squarely covers the circumstances of the case. The explanation to section 37 goes as follows. The court of first instance does not cease to have jurisdiction to execute a decree merely on the ground that after institution of the suit, wherein the decree was passed or after the passing of the decree, any area has been transferred from the jurisdiction of that court to the jurisdiction of any other court. But in every such case, such or other court shall also have jurisdiction to execute the decree if at the time of making the application for execution of the decree, it would have jurisdiction to try the said suit. So from the aforesaid provision of law, it transpired that the court which actually passed the decree doesn't lose its jurisdiction to execute it by reason of the subject matter being subsequently transferred to jurisdiction of another court. Now, in the present case, decree is admittedly for recovery of money against the government of Assam in respect of the common work order, partly for the work relating to the subdivisions under the Dhubri and partly for the subdivisions under South Salmara Mankacher district. So in view of that matter, even if the part of Dhubri is bifurcated and merged with the South Salmara Mankacher, I am of the considered opinion that this court does not lose its jurisdiction as the decree is against common work order, which is inseparable, and it is against the government of Assam who carries on business, who is functioning in all districts of the state of Assam, including Dhubri and South Salmara Mankacher district, through its various offices, primarily Deputy Commissioner's office. Furthermore, under the circumstances of this case, the principle of where the cause of action arose also appears to have lent support on the point of territorial jurisdiction of the court. That reason being that the matter under consideration is for the recovery of money due to the plaintiff or the party, the decree holder for the contract entered into by for repairing ballot boxes of Dhubri and for the work done at the Messrs. Chemex Industry of Decree Holder situated at Dhubri. Therefore, the conduct of the judgment letter number 2 also reveals that petition of the judgment letter number 2 is not maintainable as the same request to be barred by principle of estoppel. The continuous participation of judgment letter number 2 in execution proceeding before this court and seeking time for the payment of decretal amount for more than 3 years, even after bifurcation of South Salmar Mankachar from Dhubri district without any objection, clearly shows that by acquiescence, the judgment letter number 2 has submitted to the jurisdiction of this court. Furthermore, the failure on the part of the judgment letter number 2 to show any cause as to how he would be prejudiced if the decree is executed by this court clearly indicates towards the fact that related objection of judgment letter number 2 relating to territorial jurisdiction of this court is without any probable and reasonable cause and was made just to prolong the matter further relating to execution of decree so that the decree holder is deprived of the enjoying the fruits of the decree. Hence, from the above facts and circumstances, I am foreclosed from all sides to hold that this court has got the jurisdiction to entertain this execution proceeding. Accordingly, petition number 7 filed by judgment number 2 is hereby rejected. Let the execution proceeding be proceeded ahead. The order directing the stay in the execution of the writ of attachment is hereby vacated. Bailiff is directed to execute the same as per order and announcement immediately and submit compliance report accordingly, as any further delay in my considered opinion may cause serious hardship to the decree holder who is fighting to get the fruit of decree for last 8 years. Decree holder is to take steps accordingly in this regard. Now, pursuant to this order, possibly, my lord, attachment of certain official, the almirah, etc., my lord, all movable, of course. A list has been prepared by the Najid and attached for realization of the money value by sale, etc. And I am raising 2 points here. First of all, my lord, when this court, my lord, page 66 says, my lord, this explanation of section 37, if at the time of making the application for execution of the decree, it would have jurisdiction to try the said suit. Now, when the application was mailed, by that time, my lord, the Mankachar district came already. So that court of Dhubri did not have jurisdiction. This, in order to, my lord, sir, my lord, somehow overcome this hurdle, the Honorable Court says it's a common order. It may be a common order, my lordship may kindly have a look at the plain. It may be a common order, but the bill in respect of which this money suit has been filed, plain start from page 17. Page 17, my lord. Page 17. Plain starts, I'm straightway going to page 19, para 3. Para 3, that subsequent to the completion of the aforesaid repairing, greasing, oiling, painting works of ballot boxes in connection with Panchayat election 2013 for Dhubri, Bidasipara and Hatsingmari subdivisions of Dhubri district, Assam. The plaintiff submitted respective bills as per approved and scheduled rate for Panchayat election 2013 to the then Deputy Commissioner Dhubri Panchayat election cell. For Dhubri, Bilashipara subdivision, the plaintiff also submitted bills as per approved and scheduled rate for Panchayat election 2013 to the Deputy Commissioner Dhubri Panchayat election cell. For Hatsingmari subdivision, which are specifically mentioned here under. And this is the bill of 6,13,000. This is in respect of Hatsingmari subdivision. Now, the Hatsingmari subdivision decree has been passed in respect of Hatsingmari subdivision. My lord, next paragraph, also kindly see that out of the total amount of bill under Hatsingmari subdivision, Dhubri district, Assam, as referred to above in paragraph 3, the plaintiff had received as part of payment thereof rupees 1,36,000 and odd, and rest of the amount of so and so is yet to be received by the plaintiff. In this connection, the plaintiff sent letter by number so and so, dated so and so, it is 7/8/2013 and 17/10/2013 to the Principal Secretary, Panchayat and Rural Department, 6 Mile, Guwahati, wherein the plaintiff internally prayed for making payment of the below schedule balance amount of bill under Hatsingmari subdivision, Dhubri district, intimating the then additional deputy commissioner Dhubri and in charge panchayat election Dhubri and the defendant number 2 for favor of kind information and necessary action in this regard. But none of the aforesaid 3 authorities paid any heed to such letters of the plaintiff. Well, two things I am showing from here. First of all, the bills are in respect of Hapsingmari subdivision. Decrees sought to be executed against the office of the deputy commissioner, Hapsingmari subdivision. The court is in Dhubri. Dhubri cannot execute this against him. This part has already.
Originally, the order was issued from Dhuri.
Originally
At that time, Hatsingimari was subdivision.
Yes, originally it was there. Now, after it is, my lord, the new district has been created in terms of section 36, my lord.
No, the thing is that both the districts are under government of
My lord, your lordship is correct. My lord, in fact, what happens here is, my lord, it is the state election commission who is to conduct. But if your lordship goes to the panchayat, Assam Panchayat Act, I'll show two things. Section 114 says, State Panchayat Election Commission, Superintendent's direction and control of the preparation of electoral roll for and the conduct of election to the Panchayat shall be vested in the State Election Commission.
No, maybe it is a department under the Government of Assam.
My lord, so far
you tell me what relief I can grant you.
My lord, what the objections that I am taking all are technical objections. Ultimately, it is the fund will come possibly from the state government. It is for the State Election Commission to bear all the expenses. Deputy Commissioner, my lord, I'll just lordship may kindly see this subsection 3. The government shall, when so requested by the state.
No, the work order was issued in the name of Deputy Commissioner.
Yes, my lord, Deputy Commissioner. Now, bills in respect of which the money decree has been obtained are bills for repairing of
ballot boxes.
For Hatsingimari. Bill, there were 3 separate.
No, but you cannot abdicate your duty as because Hatsingimari is a independent district now. Because
In terms of section 39(4), it has to go there, my lord. I'm just reading that provision, my lord. Transfer of decree, section 39.
No, Mr. Mazumdar, without going into the technicalities, why don't you pay the amount? The amount is very small.
My lord, difficulties not with regard to payment. Difficulties, the whole proceeding is against the Deputy Commissioner of Hatsingimari district. Deputy Commissioner doesn't have any fund for that. It is for the State Election Commission to make money. That's why I'm showing, my lord. It is for the, my lord, the Deputy Commissioner's office will only provide the necessary, my lord, assistance. The entire job is for this Panchayat and Rural Department. Ultimately, it will go from the state exchequer, my lord.
No, if say unless you deposit the security amount, we cannot stay the money decree.
No, I'm not paying for stay of money decree.
Then
today, what I'm saying is, my lord, lordship may kindly stay because it's an attachment of the all government offices, Almira, etc. This will halt the functioning of this office of the Deputy Commissioner. Lordship will stay for some time, and I'll see. I'll try to utilize my office also to see that they get the money, because money decree, so long as decree is there. Today I am taking a technical plea, but ultimately, if this district or that district, they will have to be paid the money. That I am accepting, madam. But technically, this order is not correct because the manner in which section 39(4) has been interpreted, along with the explanation to section 37, if we go by that interpretation, that order is wrong. Because it says it's a common order. Order may be common, but then 3 bills are in respect of 3 different places, and one of the district for which the suit has been filed now falls in Hatsingimari district. So that way, the decree has to be transferred to Hatsingimari district for execution. And accordingly, this objection was raised by the deputy office of the Deputy Commissioner. That application has been rejected. Technically, this order is not correct. And secondly, my lord, it is ultimately the State Election Commission.
No, even then, it is the decree has been passed.
My lord.
How can we stay it now?
My lord, the order is technically wrong. But ultimately, yes, if once it goes to the district of Hatsingimari, then or money will have to be paid to them. That is correct, to the decree holder. That's why I'm saying, my lord,
Yes, Mr.
presently-
Dubey, you are for respondent number 2. Go.
Lord, let me clear two things, Lord.
Hmm.
Lord, State Election Commission is not an agency under the government of Assam. It's a constitutional authority under the scheme of our constitution, Lord.
Hmm.
But our duty is to conduct elections. We are not the paying and drawing and disbursing agency. It is the PNRD department which allocate the funds for elections of panchayat elections. Second, my lord, we are not a party either in the execution proceedings or in the money suit.
Hmm.
So, my lord, we can't be here, my lord. So I am therefore praying that our name should be strike off.
My lord,
Because it
if
is-
we. Please.
And Lord, if what has come forward as a statement from my learned senior friend, Lord, that it's our obligation, Lord, that would be opening up Pandora's box, Lord. Because there are many writ petitions here which are being adjudicated as regard payment of election bills, Lord, where the direction has been issued to Panchayat and Rural Department, Lord, and they are also taking concurrence from the Finance Department. We are the conducting agencies, Lord. And the Deputy Commissioner did act under the supervision of the Election Commission. But when the suit was filed, it ought to have been pointed out, my lord, that necessary parties are not there. So if I am not there, I am not there, my lord. And I could not be brought in at this stage. And it is not my responsibility to pay, my lord. And the merits,
And,
my
who
learned
is
friend,
for,
Lord, I don't oppose or disagree with him.
Who
But
is for
my-
respondent number 3? Respondent number 3.
Lordship, PNRD was also not a party in the previous proceedings.
Both in title suit as well
Yes.
as in
Otherwise, one state agency is making
Execution
the other
proceeding.
state agency a party, my lord. Your lordship would see, so far as state is concerned. They should speak in one language, my lord.
My lord, to be very, my lord, precise, the decree itself is not sustainable for the simple reason, lordship may kindly see page 17.
No, but can we
My lord, the suit has, if the suit is filed against the state, then state is present everywhere within the territory of the state. Then decree can be executed anywhere. But state is not a party here. They make deputy commissioner a party. That way, when a suit itself will not lie because money will have to come ultimately from the state exchequer. State is not a party. The decrees, that way, my lord, decree is not sustainable in law. The whole problem arose because the plaintiff did not make PNRD a party. Had he made the PNRD a party, he would have got the money long back. PNRD is the authority from which the money will come. PNRD is not the party. PNRD is keeping, maintaining a silence. My lord, I have annexed all those letters from the Deputy Commissioner's office. Time to time, letters are being written to the Department of PNRD. They are not responding because now no order is coming from the court side. Lordship may kindly have a look at page 17, how they have made the party. Suit itself is not maintainable.
No, in this revision petition, we cannot examine those aspects.
My lord, we have come against an order passed by the executing court. The executing court ought to have gone up. We filed the application even under section 47, my lord. Your lordship is aware.
No, in the Manisot, the state of Assam is a party.
No, my lord, lordship kindly see.
No, page number 27.
No, my lord, no. State of Assam, they have mentioned. State of Assam represented by the collector. Collector cannot represent the state, my lord. Under the civil procedure, it is only the secretary of the government department, the state.
No, in the judgment, it has not been mentioned that state of Assam is mentioned.
My lord, state of Assam is mentioned, but the collector cannot represent the state of Assam, my lord. That is why there is no my lord, defense from the state. They should have made the Panchayat and Rural Department Secretary, Panchayat Rural Department to recover the money. Now, suit has been filed against the SDO and the collector. How can from where the collector will pay the money, my lord? If your lordship adjudicates
It is he who had issued the order.
Who, my lord?
Deputy Commissioner,
Deputy,
Collector.
My lord, that's what I'm saying, my lord. Deputy Commissioner will issue the order because Deputy Commissioner is functioning to assist the Panchayat and State Election Commission. The thing is like this, my lord. The election is for the Panchayat and Rural Department, my lord, for Panchayat Raj institutions. under the law, my lord, State Election Commission has to conduct the election under the superintendence and supervision of the my lord, State Election Commission. They conduct the election. Now, so far, that's what I said, my lord. The section 114, subsection 3 of the my lord Panchayat Act says the government shall, when so requested by the State Election Commission, make available to the State Election Commission such staff as will be necessary for the discharge of the functions conferred on the State Panchayat Election Commission. So we have to only provide the staff. So they take the assistance of the Deputy Commissioner for staff, support staff, etc. Otherwise, they conduct. My lord, had the, that's why I'm saying, my lord, had in this plaint, my lord, the PNRD been made a party, by now he would have been able to recover the amount itself. He has made Deputy Commissioner as a party. So the defect is in the plaint itself.
No, there is defect in this petition also. They are not a party in either of the proceeding, neither in title, money suit, and nor in the execution.
I agree. Before this court, we cannot make a person or party for the first time respondent here. That is correct. I am not on that matter. They are here.
You do one thing, you obtain instruction from the government how the matter can be solved.
My lord, that's what I'm saying, my lord. All the objections that I'm taking are all practically technical objections. Otherwise, if there is a decree, money has to be paid. It is another thing that the decree has been passed in a suit where state is not a party. That is an admitted fact, my lord. This is the problem for which he is not getting the money. He has made a state of Assam represented by collector. Collector cannot represent the state, my lord. Your lordship is aware of that.
Maybe there may be some mistake also, but you cannot abdicate your duty. So we are listing it on Monday. You in the meantime you obtain instruction.
No,
we are not in favor of granting any state.
My lord, I'll pray for a slightly longer time so that I can my lord, impress upon the Deputy Commissioner that this way or that way money has to be paid to them. And I'll also see that how the PNRD is working, because ultimately money has to come from the PNRD department. I'll try to find out why PNRD is not paying. So all these things should be given slightly longer time. 2 weeks time, in the meantime, possibly we'll be able to sort out.
But there shall not be any stay. Headmaster D. Mazumdar, learned additional Advocate General, and Mr. Dubey, learned counsel for the respondent number 2, and Miss learned counsel for the respondent number 3. List the matter after 2 weeks for further consideration.
Only one thing, my lord, I'm not asking for stay of the impleadment order, but only they should not sell it. Attachment will remain, my lord. They will not sell it. That much protection.
Otherwise, they will not. They will not sell.
Sold, my lord.
No. They will not sell it. Don't worry.
Lord, may kindly mention that status quo as on today, so they don't swear it. Once it is sold,
no, status quo means it is
no, attachment is already done. Attachment is already done. They have given a list. I am not praying for a stay of that. As your lordship is indicating that no stay. Lordship may kindly have a look. This, if this is somehow put to sale, there will be some difficulty. They should not sell it. This much, lordship may.
Pardon?
They should not sell it, because once it is sold, then nothing will remain.
No, they will definitely be.
All office materials of the office of the Deputy Commissioner. I'm trying to somehow see that they get the money within these 2 weeks.
No, even after selling of this article also, the entire amount cannot be recovered. Definitely, they will not take such a step.
This will cause only some harassment to the office of the Deputy Commissioner. That is why I'm saying. Otherwise,
harassment is caused to the other side also.
Well, that is why I'm trying to resolve it, my lord. That I'll try to interact with both the departments.
So after 1 week.
After 1
not 2 weeks.
Let it be 2 weeks then.
No.
Lordship may kindly fix a date, man, so that I can.
Yes. 1 week.
4th October.
12th.
4th October.
Yes.
Next item.
For bail hearing, item 25.
May I please, Your Lordship? In this case, my lord, your lordship was pleased to call for the scanned copy of the case record, my lord.
Yes.
Okay, but this is the second bail application, my lord. Earlier, your lordship was pleased to reject the same, my lord, on the ground that, my lord, that it was moved on the ground of parity and medical ground, my lord. The merit of the case was never argued, my lord.
Medical ground.
Medical ground and parity, my lord. Because other co-accused persons were granted bail, and she is the main accused, my lord, and on the ground parity law parity is not applicable, and she is the main, as your lordship has held.
Says
as law parity is not applicable, parity means there are other co-accused persons are there now. They were granted bail, man. So on this ground that she is not entitled for bail, she is the main accused, and there is involvement of more than 105 crores. That your lordship's finding, man. That your lordship finding the order itself. I'm placing the order before lordship. That they page 121, man. Paragraph 4, my lord. Essence of the allegation made in the FIR, it says that accused was serving as joint secretary to government of Assam, come executive chairman, come director of OTL cell.
You come to the finding of the court.
Yes. Now your lordship will find subsequently, my lord, that page 120, paragraph 8, my. It is not disputed that the accused was arrested on 8/5/2023. Since then, she has been languishing in jail hazard. It is also not in dispute that the amount misappropriated here in the case is 1054. But the non-counsel accused has not addressed the court on the merit of the case, but emphasized on the ground of women being sick, on the ground of parity, and also on the ground of length of detention. Then contents of that the accused is sick, suffering from different elements. That third part, my lord. Now, your lordship, finally, my lord. Then he has stated that about the being a woman on the ground of length of detention, and then your lordship come to paragraph 10, my lord. I found this is the unimpressive in the enormity of the offense view of the huge amount of government revenue siphoned off in collusion with the co-accused, some of whom are our family members. Moreover, it is being economic offense. It need to be visited with different approaches as held by Supreme Court in It is mentioned by in Nimagana Prasad following Supreme Court case law, your economic offense constituted class apart. That your lordship has quoted the decision of Supreme Court, my lord. Thereafter, my lord, paragraph 12, my next page, my lord. In fact, the investigation has already been completed and charges has been filed before the court, and now the case is pending for prosecution censure. Now with settled so the charge is filed within the 90 days. The right to be released always cannot on merits only, but in case in hand, the has not addressed the court on the merit of the case. And this simply some of the accused has already been enlarged. It appears the material time concurrence of the accused was serving as a joint secretary, come executive chairman, come direct. Role played by her commission of the offense is serious than the role played by co-accused, who has already been enlarged on bail. On this count, Lane PP submitted the cases of accused not same still that of other accused. On the ground of parity, she is not entitled. I find force on the submissions and the case law so and so, and advance this argument, which is held that it may noted that parity is not the law. While applying the principle of parity, court is required to focus on the role attached to other accused. But having considered submissions so and so, considering the nature and gravity of the offense, and the punishment was balancing the individual interest of the accused with that of the social interest, this court of view that is not fit case, privilege of bail and granted accordingly petition of this case. Now you are so far the merit is concerned with 105 crores. That actually is not a correct picture that has been projected by the prosecution. In the charges itself, they have stated that this amount was not misappropriated. I'm taking to the charges, your lordship, kindly come. That was the case in the FIR matter. Subsequently, the search sheet matter. Relevant pages, I'm coming to it, matter. That your lordship will kindly come to page 103, my. Madam. That paragraph 16.03, madam. Their FIR was registered based on the findings of the inquiry report as per approval of the Chief Minister of Assam, communicated by order number so and so. Brief allegation is FIR, the government of Assam has submitted a proposal of NCT for introduction of D.Ed program to distance mode. NCT issued permission for 59 recognized teachers education institutes like DIET, basic training schools, normal schools and study center, with intake capacity of 1,000 each. Total 27,897 government teachers. But in contravention of the above approval, there's a petitioner, there's Sawali Devi Sharma, then the chairman come director of ODCL opened up 347 study centers, enroll 1,68,828 number of trainees against the approval of 27,897. Therefore, 78,900 trainees were enrolled in the program in the violation of conditions stipulated to enroll. 28 numbers of additional study centers in private institutions and study centers were opened in violation of NCT guidelines. As per so and so, no objection certificate from the Distance Education Council should have been obtained for running the DID for 2 years duration, but no such certificates were obtained from Distance Education Council. So these are the violations she has done, my lord. Now your lordship will coming to the other part, my lord. Page 106. Page 106, you will also find the DED course to ODL Center mode under so and so 22 NCT National Council Training recognized teachers education 18 that or phone numbers from the director so and so. Though NCT issued permission for 59 recognized teacher institutes so and so for basic training, normal training and study center with intake capacity of 100. But ODCL has opened 347 study centers, enrolled 1,68,228 trainees against the approval of 27,018. Therefore, 78,000 individuals were additionally enrolled in the program in violation of conditions stipulated so and so. So 218 of additional study centers were including some private study centers were opened in violation of NCT guidelines. No NOC was distance training so and so was obtained for study centers in the private institutions. The list was given, my lord. Then you will also kindly come to the next page, slide. Regarding the money part, my lord, that is page 108. The fee structure. The fee paragraph 0.08. Fee structure for each government teacher was fixed as rupees 6,750 approved from the government was taken as fees for each government teacher. For private teachers, 12,000 approval for fee structure for private teacher was not for as also fixed 12,000 for fee structure for private teachers was not short but fixed as rupees 600 acquisition fee. Eligible contributor of each study center collected the fees of the trainee teacher in cash. Therefore, deposit 80% of the amount of admission fees and 100% of the examination fees in the account of ODCL by SCRT, RGTS, NET, cash or check, madam. Then your lordship will kindly come, page 189. During inquiry, it was found that out of 1,68,288 trainees, out 99,000 trainees will appear in the first examination in various study centers. Total so and so number of trainees appeared in second year, out of which 95,900 trainees were acquired DID certificate. Those certificates have been acquired and they have been acknowledged by the government, and on the basis of them, the selection was also made subsequently. Now your lordship will find regarding the monetary part, what they have stated, that on that your lordship will find at page paragraph 14, mile. On perusal of income expenditure account of so and so, the following amounts were received from ODCL: admission fees and examination fees, including bank interest on perusal so and so. This is the amount was received is 95,52,000. Something as on 31/7/2020, 1,24,63 was has been received by ODCL cell. So this money has come from the fees given by the enrolled teachers. It is not from the government exchequer as administrated. Now what has happened? This money has been used for opening of the study centers. And while opening the study centers, they did not follow the norms. Now, next page 111. As the funds are received from different government and private institutions which conducted 2-year degree course under ODCL, page 111. The fees collected as per candidate was 6,075 from private teacher fees as received was 12,000. Both government private had to deposit 80% so and so. But there is no record about list of institution amount collected deposit so and so by requisite institution with the so and so. Fund received by ODCL could not be ascertained properly thoroughly. Fund was received above as calculated as per the cash book and bank statement. During the fund so and so open 5 accounts number so and so. Then they have stated, my lord, your lordship will find. During the investigation, so and so as matter was relating to private, it was given to private place for printing, so and so printing work was done by. Now, according to the bank, I'm not going to other part. So regarding the expenditure part, they want to say, my lord, that the paragraph your lordship may kindly say paragraph 116, my 116, my lord. From the cash book, it appears, my lord, that it was found a total amount of 1,15,00,000 was spent by ODCL with effect from 31/7/2002 21/3 which was calculated by bank as there is no chronological vouchers were maintained. Expert team from so and so, vouchers produced by IO, which were received from our contractors, not from the records C so and so. So this is not a case of misappropriation. Study centers were open, private study centers. So printing press, my matter was collected, construction was done, and teachers were trained, certificates were issued. The only question is that their permission was not obtained. And the manner in execution might have gone so far as there is a preferential source, preferential act, there because there is a violation of the, according to the prosecution, my lord, there is a violation of the rules, my lord, regarding appointment of contractors, my lord. That was not done. No tender notice was issued. So the narrative has been issued that I have misappropriated 1 crore filings. That is not a fact, my lord. And now your lordship will kindly see what is the stage, my lord. It is stage of only copies has not been furnished. I've been in internet for more than 15 months. And no copies have been furnished to me. Only partial copies were given. And now, because of the High Court rule says, by law, unrelied documents has to be furnished also to us. Documents which are not relied by the prosecutor, that also required to be furnished. So it will take more than a year.
You hesitated that issue before the learned trial court.
No, I understand, but wrong incarnation with your lordship may kindly see. Because
What this court can do while dealing with bail application?
yeah, because considering the nature of the case, my lord, you already have projected, my lord. It is not a case that I misappropriated the whole amount. That's what I'm to say there. Because this is a case on my accounts. Whether actually amount was actually amount that has been collected, what has been, no money has been taken out from the exchequer. It is the fees of the teachers and who has deposited the fees in the account. From that fees, we have.
And who collected the fees?
Fees was collected as per the government rules, my lord. It was
Government
deposited
rules.
in the OTCL sale.
Whether says not an employee of the government,
Who, my lord?
the accused?
Accused was employed, but that was because he has actually he has to.
And in what capacity you have collected the money and misappropriated the same?
That's not the question. We have deposited the fees, and from the fees we have opened the study centers. Study centers were opened, my lord, and that was naturally they have to opening the study centers. We have to report the expenses, my lord. Printing press materials were there. The construction was done for purpose of training the professors, for training the teachers, and naturally the expenses have to be incurred by the OTCSL. Only that as per the procurement rules.
So whatever observation was made in the order of this court, that was based on the documents placed before this court.
Yes, understand. But
If you have any grievance, you go to the appropriate forum and agitate the matter there.
I'm not talking about. I'm saying that actually the
Because
fact that,
this court cannot review its earlier order.
that your lordship has gone to the FIR only. That story subsequently it has come light during the investigation.
Yes, there is a trial court, base court. You can go there.
But fact remains, your lordship may kindly see. Now, the fact, in view of this decision of money security, I am referring your lordship. Now, this your lordship will find that is paragraph 145 of the judgment, where they have stated that economic offences, your lordship may kindly see. There, your lordship will find page number 145, my lord. Page number 145. Before sponsoring the submission of learned ACC, we regard the maintaining with the present appeal on record, second order of this court, it is imposed to refer to certain objection codes. We also concerned with the prolonged period of incarnation suffered by the appellant money security to ensure the appellant granted bail after being kept in custody for 49 days, relying on Constitution of Sri Gurbakh Singh Sikh Baba, State of Punjab, Sanjay Sundar Bazar, State of CBI. Even if the allegation of one of grave economic offence, it is a rule that the bail should be denied in every case. It is not a rule that bail should be denied in every case. Ultimately, consideration has to be made on case-to-case based on the facts. Primary object is to secure the presence of the accused to stand trial. Argument that appellant here is a flight risk or there was a possibility of tampering with the evidence or influencing the witnesses was rejected by court. Again, in Satinder Kumar Atil versus CBI, another this court referred to Surendra Singh and allies Singhara Singh, State of Punjab, and Kashmir Singh, State of Punjab, where emphasize the right of speedy trial is a fundamental right within the broad scope of Article 21 of the Constitution. In Vijay Mandal Chaudhary, this court highlighted a view of economy like money laundering.
Mr. Kotoki, you have to prove that your right is violated. right to speedy trial is violated.
Yeah, that is
Then
violated
you have to show how it is violated.
because violated.
Merely saying that my right to speedy trial is violated, it cannot.
No, violated in the sense, your lordship kindly see. I was the case was succeeded, your lordship kindly see. When it was succeeded, it was succeeded. It was succeeded. Final report was submitted on 2/7/23. More than 1 year has left. One my lord. As of today, they failed to supply the copies. Your lordship may see.
Yes, Mr. Fukan.
My lord.
Why the documents could not be supplied?
Here, my last occasion, the status report was called for, my lord. Where it shows on 5/9 of 2024, my lord. The part of the copies were furnished to the accused persons. And again, the fixing of matter, my lord, on 19/9 of 2024. Production of the accused, the present petitioner, Sevali Devi Sharma. And on 3/10 of 2024, for fixing remaining part of the copies of the accused persons, my lord. That's the status report has come. The part copies has been given, my lord, and the another remaining part will be given on 3/10, my lord.
No, Mr. Pukul, nowadays in every court, this Xerox machines are available.
My lord.
But they have given it pen type, not in Xerox machine. We have to get it in Xerox. Your lordship may kindly see this.
So if this kind of practice is going on in the trial court, then what option is available to this court
My lord.
instead of granting bail? If you take 1 year time for furnishing, complying the provision of section 207 CRPC, then
Well, it's true, my
how
lord.
many years you will take to examine how many witnesses cited?
Cited, my lord. 83 witnesses, my lord.
82
My
witnesses.
lord, yes. And there is also, my lord, voluminous records are there.
Pardon?
Voluminous records are there.
Voluminous
My lord,
records.
yes. That's why, my lord, time. It's not that, my lord, only 100, 200 pages are there, my lord. There are trunk physical, my lord.
But they have in the order sheet also it appears in 118, my lord. It is voluminous.
Because in the trial court, my lord, not only this case, so many cases are
No,
all cases, my lord.
That's all right. So many cases are there.
My lord, yes. Because all are,
But,
my lord, in the special courts of PC cases are there, my lord. So PCA cases are there. As such, my lord, in all cases, my lord, trunk-wise, my lord, records has come, my lord. That's why difficult to.
But Mr. Kotoki, you briefly tell me the grounds for preferring this second application.
Second application is basically on the ground of incarnation.
On the ground of?
I've been incarnated for 16 months, my lord. And I was in jail for 16 months, my lord.
16 months.
And charge sheet was submitted way back in the year 27/7/2023, my lord. And only partly copies was furnished to me, my lord, by the order dated 16/5/24, my lord. The inspection yet to be done, my lord.
Any other ground?
And the ground, other ground also regarding the charge sheet part, I have already pointed out, my lord. That actually that misappropriate amount, that amount actually it is a question of accounts, my lord. And when it's a question of accounts, that on the going through the documents only we can find out whether actually amount is misappropriated, because they have also not, there's no specific finding this amount was misappropriated. They say that I did not properly maintain the accounts. That is the question. But certificates that have been issued, my lord, whatever there's a violation of rules regarding the procurement of articles, because there's a rules of government rules were violated, that I admit, my lord. But amounts over the amount is concerned, actually the amount that has been meted, that has not been come out in the charge sheet. That's the expenditure part. And secondly, since it's a voluminous nature, we don't know how long it will take, my lord. It may take 2-3 years for inspection of documents also, because inspection of documents yet to be started, my lord. And since jail, my lord, it is difficult for her to come all along for inspection of documents also. And that apart, she has been suffering from the disease, my lord, that is requires cirrhosis disease at 4th stage, my lord.
Suffering from?
Liver cirrhosis. Liver cirrhosis and some depression was also there. The doctors have advising my lord that is space 135, my lord. That is given by the Department of Clinical Psychology, my lord.
She is suffering from liver cirrhosis
as
and
well as
the
depression.
certificate was given by clinical psychologist.
Clinical signs are because of depression, man. Because
Yes.
yes, that his family members asked to meet the patient regular time at least for an hour every day. If possible, disturbed almost all the time from communication could not help her settle as respite the case. So she was someone depression. The family members were asked to visit the jail every day. Man. That is a difficulty because she doesn't want to communicate to anybody. There is another thing, my lord. And secondly, my lord. And 137 is the report given by the regarding the CAP report by regarding the 35, that is the cirrhosis part by because of fatty liver and all this. So that are also medical condition is also not improving, my lord. It requires urgent attention. It is difficult for each of the members to go every day, my lord. So,
Yes, Mr. Fukan.
My lord. Here, my lord, first of all, my lord, the argument is led by my lord, friend, my lord. Say that this is in the case of the amount which was my lord expenses is not from which was not misappropriated. All these things are my lord come into at the time of trial, my lord. It is not the stage, my lord, they saying yes, this amount is coming from such and such place and this amount was incurred in such and such place, my lord. It is not comes at this stage, my lord. It is a matter of trial. And moreover, my lord, the asking about the copies. The copies, my lord, already report has come, my lord. The first part, my lord, one part of the copy has been given, and the remaining part will be furnished on 3/10 of 2024. Because it's, my lord, there are 2, 3, 4 trunks are there, my lord. It's very difficult to furnish at a time, my lord, all the documents to the, my lord, the petitioners, because they're quite voluminous, my lord. And number 3, my lord, they have taken a stand, my lord, the length of detentions. In the length of detention, your lordship very much know, my lord, your lordship has already decided in the earlier order, my lord. The length of detention is not a criteria in case of the economic offense, my lord. Where the, my lord, these economic offense are not treated to be as a, my lord, class treated to be as class effort, not treated to be as a general offenses. And third point, my lord, the fourth point, they have, my lord, they say that the medicals, my lord, the issues. In this regard, my lord, on 9/1 of 2024, my lord, their medical board was constituted, where the patient was found that, my lord, she was examined by assigned by medical board.
Who is that?
That is on 9/1 of 2024, madam. The January 2024, my lord, 9 January 2024.
No, since then more than 9 months elapsed.
My lord, yes. The reports I have, my lord. The 9 months before, my lord, she is quite stable, my lord. There is no report we have found in my lord. The liver cirrhosis cannot be, my lord, happen in 1 day, my lord. So in the 9 months before reports, we have not found any liver cirrhosis report. Where we have found only, my lord, the past history of the type 2 diabetes, mellitus with a hypertension, primary hypothalamium, and B, thalassemia minor with history of chronic liver disease, NAH related, and solitary rectal ulcer. There is also a part of history of the hysterectomy and appendectomy in 2009. And the medication prescribed, my lord, some Rezodi is a, my lord, the gastro tablets and all, my lord, so given to her. And moreover, my lord, the length of detentions, my lord, already lordship have been deciding the other order.
Yes, so Mr. Kotoki, on what basis he was submitting that she has been suffering from liver cirrhosis?
Liver cirrhosis, first of all, your lordship will find page 133. That was
133.
133, man. That was before she was taken into custody, my lord. That is what on 9/7/22, my lord. There she was suffered for hypertension, diabetes mellitus, iron deficiency, then liver cirrhosis and S-bar ES, my lord. Then she was referred to Apollo Hospital, Chennai. That was there, my lord. That before that. Then thereafter, my lord, he was treated as a outpatient department in the GMC, my lord. After she was taken into custody, my lord, and on regular basis, my lord. And And thereafter, your lordship will kindly see at page 136, my lord. The associate professor of head of department of clinical psychology, Guwahati Medical College, my lord, 136, where there is supportive work is done. The liver, actually, that liver resume. So doctor's handwriting, it cannot. Family members are asked to meet the patient regular basis for at least an hour every day, possibly. If they feels this stuff almost all the time, and some communication manipulation could help to state the requisite as a respite case. Then you also will find next is the Department of Gastroenteritis. On 15/3/24, my cap report they have given, my lord. 335. 335, my lord. 29/1/2010. That and as per the information that we have gathered from Google, that is page annexure 11, page 138. If it is 2292 to 400 is S3, my lord. Stage 3 of the cirrhosis, my lord.
Now, observation.
Liver failure, my lord. And 139 says stage 4 is a liver failure, which your liver cannot longer function, heal itself. Liver failure, liver can longer process.
No, this is only. Is it related to present petitioner?
Yes.
Department page number 138?
138, 137 is preloaded. 137. That is the report of the GMC, man. 15/3 after the board constituted. Board, according to Mr. Fukan, board was constituted in the month of January. And that is the report of 15/3/2000. Where her found was, cap was found with 335.
Okay. Heard Mr. Kotoke, learned counsel for the petitioner, and Mr. M. Kokon, learned PP for the state of Assam. Argument concluded for the result.
Item number 45.
Much obliged.
Can it be taken after some time?
Item 26, letter under hearing, rule to CPC.
May it be your lordship. Pursuant to the permission granted by our lordship that the appellant has incorporated the substantial questions through law.
Yes.
And
you have incorporated
lordship at flag X. At flag X, lordship.
flag X.
Lordship.
Okay.
Many grounds are about only relying on only 3 grounds, 1, 2, and 4, lordship.
1, 2, and 4.
Lordship.
Okay. Headmaster,
R.P. Kakoti.
learned counsel for the appellant.
Lord.
Senior advocate, assisted by Mr.
Yes, Sutodas.
Learned counsel for the appellant. The second appeal is directed against the judgment and decree dated 12/2/2021 passed by the learned civil judge Karimganj in title appeal number 34 of 2019, thereby upholding the judgment and decree dated 23rd/4/2019 passed by the learned Monsif number 1 in title suit number 107 of 2012. Where is the judgment of the trial court, Monsif?
At page Lordship 6.
Page
Or trial court Lordship page 32 Lordship.
32.
Lordship.
Is to be noted here that by judgment and decree dated so and so, the learned trial court. Decree dated 23rd/4/2019, the learned trial court. Decreed the suit. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree passed by the learned first appellate court in title appeal number so and so, and also by the learned Monsif in title suit number so and so. This second appeal is admitted on the following substantial question of law. Number one, whether a suit filed for declaration of the plaintiff as the owner and occupier of the suit land can be decreed by the learned trial court by ignoring the government survey report, wherein a part of the suit land is recorded as disputed land for having found the same under the possession of the defendant as its owner, more particularly, while both the plaintiff and the defendants had admitted the said survey report. Number two, whether the first appellate court was justified in dismissing the appeal preferred by the defendant, challenging the judgment of the trial court, whereby the plaintiff was declared as the owner and the occupier of the suit land, by ignoring the government survey report wherein a distinct part of the suit land was recorded as disputed land for having found the same under the possession of the defendants, whose report was admitted by both the plaintiff and the defendants, and the plaintiff having not disproved the correctness of the said survey report. Number 3, whether the first appellate court ought to have remanded the case under Order 41 Rule 25 of the CPC to the trial court in order to decide the issue created by the report of the Assistant Settlement Officer, whereby if part of the suit land has been registered as disputed land and the same having been found under the possession of the defendant which could not be proved to be wrong by the plaintiff before the learned trial court. Whether any issue was framed by the Monsif?
Yes, His Lordship is prepared. At Page 41, Lordship.
No, there is a no issue in respect of the survey report.
No issue was framed, Lordship, that, but it has been discussed by the learned trial court as well as by the appellate court. Lordship, at page.
So
40.
have you mentioned it in the written statement about the government survey report?
Yes, it was mentioned, Lordship, that unfortunately, Lordship, it is a case between two tea companies, Lordships. And that appellant now, who owns that Longai Tea Estate, Lordship, which is filing now, for the fault of the manager of the company, after filing the WS, no steps were taken till the disposal of the case. Because of some peculiar reason, but in WS it is stated that in the report of the
No evidence was adduced.
no, nothing. That's why that the prayer was made in the appellate court to remand the case back to the trial court so that they get an opportunity for sake of justice, Lordship. That was not allowed, Lordship. That's why, Lordship, the order 41 Rule 25.
No, as no evidence was adduced.
But it's,
it's
an admitted fact, Lordship, will kindly turn to page para 26 of the trial court judgment, Lordship. Page 43. At para 26, Lordship. Later portion, Lordship, I read it. The PW3, bench assistant, Lordship, got it.
Yes.
From ADM Court, Karimganj, exhibited a complete case record of the aforesaid case, number such and such, as Exhibit 11, Exhibit 11-1, and also survey report, dated such and such, which is prepared by the Assistant Settlement Officer, Karimganj, as Exhibit 12 and 12-1. It may be noted that the said survey, in an admitted position of fact, is a position of fact in a written statement filed by the defendant, number 1 and 2, without any objection over the same. The plaintiff also, when it was produced, plaintiff also did not object to that. It has been explained, Lordship, may kindly turn to next page, Lordship, page 29. No, para 29, next page, para 29, next page. On the other hand, the survey report also speaks that the land measuring 6 bigha substances of Dag number 72 saw and W72 saw under tea plantation was claimed by the Longai Tea Estate, whereas the land measuring 26 bighas and odds under Dag number substances under rubber plantation was claimed by the plaintiff tea Patini Tea Estate, and thus the land measuring 32 bighas 15 costs of 1 was shown to be disputed land. Now it may be noted that subsequently during the pendency of the suit, by way of amendment of the plaintiffs limited their claim ownership of the occupation of Act number 72 over the land measuring 150 bighas and odds, only by excluding a portion of land found under the possession of defendants number 2 and 2H during the survey, but including the complete 32 bighas, 15 kosa, 1 shataku land shown in the dispute as assistant dispute by the assistant settlement officer, Karimganj. This report was proved. This report says that out of the suit land, 32 bighas of lands are disputed land. And because Longite is that is present appellant is claiming that land. And that report was produced before the Learned Court. Learned Court examined it and plaintiff did not object to that report. They accepted it. Then when the suit land, also other suit land, 32 bighas are sold in disputed land for being under possession of the defendant. How can a suit be decreed?
Okay, let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Shall call for the record from the learned trial court and also from the learned first appellate court. Place the matter after 4 weeks. Is there any stay petition?
On the stay petition we are filing, but somehow or other it will be filing. So
What's up? Okay.
we'll filing a stay petition.
27.
Deep love like.
Appellants are the plaintiff's lordship. They filed a suit for right title interest and recovery of possession. Prayer is at page 20. Lordship. A decree declaring plaintiff all right title interest on the basis of purchase by registered sale deed number, so it's a 3 registered sale deeds, lordship. Over the suit schedule B land of the plaintiff, which is a part of schedule A land. Prior to a decree for recovery of khas possession of the suit schedule B land by removing the principal defendants along with their settled houses from the possession of the suit schedule B land. A decree for compensation. My suit was rejected, lordship. The defendants filed their written statement. Pro forma defendants, the persons who are my vendors, lordship, they admitted my case. That is Annexures 5, page 69. Page 69 is the written statement by my vendors, lordship. Paragraph 4, lordship, that the pro forma defendant number 16 sold the aforesaid land measuring about 9 bigha 2 kata 10 lesser to the plaintiff by executing registered sale deed, those 3 numbers, lordship, and delivered the khas possession of the said land to the plaintiff on the same day. So they admitted my case, lordship, and prayed for allowing my suit. But the learned trial court held that my vendors have no title, so the registered sale deeds are void and illegal. Page 85, your lordship.
Page number 55.
85. On the basis of these two issues, my suit was dismissed. Issue number 3 and 4. Only on these two issues, Lordship. There was no issue that whether my vendor has any saleable right or not, Lordship. Issue number 3 and 4 was discussed in paragraph number 34. I'll take your Lordship to the relevant portion, page 86, paragraph 35. The defendant stated that the so-called vendor and vendee has no locus standi to execute the registered sale deeds. Lahore Borkotoki Kakoti had not any saleable right over the land sold by him to the plaintiff Abdul Jabbar. Thus, the defendant, although did not deny the execution of the alleged sale deeds, but stated that the vendor of those sale deeds had not any saleable right over the suit land. Hence, here the moot question to be decided is whether Lahore Kakoti had any saleable right over the suit land. Learned advocate for defendant reading argument contended that framing of an issue is necessary whether the vendor Lahore Kakoti had any saleable right over the suit land or not. However, the transaction of transfer of land shall not be valid if the vendor has no legal right to make such transfer by way of sale. Hence, the question may be decided without framing an issue. So, no issue was framed in spite of the defendant's Lordship admitted about the registration of the sale deeds, Lordship. In this regard, the plaintiff stated in the plaint that Mayaram Nath and his son Sadara Nath, Sundara Purnachandra Nath, Badan Chandra Nath, Bhagirath Nath, and Harmohan Nath were living in the same family. They had cleared up about 65 bighas, 14 lesas of land by cleaning the jungle and took possession of the same. Annual Patta number 36, old new 56 in respect of 13 bighas, 3 katha 14 lesa of land was issued in the name of Harmohan Nath. Annual Patta number 3345 in respect of 17 bigha 2 katha 16 lesa of land was issued in the name of Mayaram Nath, and annual Patta number 38, 39, 34, 48 in respect of 19 bighas of land was issued in the name of Purnachandra Nath. 19 bighas of land in the name of Purnachandra Nath was converted to periodic Patta number 70 in the name of Purnachandra Nath. The total 65 bighas, 14 lesas of land was equally partitioned among 5 sons of Mayaram Nath, and as per the said partition, each son obtained 13 bighas, 2.8 lesas of land. Each plot of land measuring 19 bighas covered by so was fallen in the share of Purnachandra Nath and Bhagirath Nath, 9 bigha, 2 katha 10 lesa of land in each share, and accordingly they were possessing their respective shares. Accordingly, Circle Officer of Mikirveta Revenue Circle granted mutation in the name of Bhagirath Nath along with Purnachandra Nath by an order dated showing Bhagirath Nath as sharer of the land. Bhagirath Nath was not living on so the said land was mutated in the name of Leela Borkakoti, and as Leela Borkakoti was also not living, the name of Lahore Borkakoti was mutated by way of inheritance. The contesting defendant stated that as per Jamabandi copy issued in the year 1968-69, Purnachandra Nath was the original owner of the Schedule A land. Schedule A land was converted to periodic Patta by petition number so dated so. Prior to and after periodic Patta, the entire land had been being possessed by Purnachandra Nath till his death and thereafter by his legal heirs. Purnachandra Nath was died in 1995, leaving behind him Girish Chandra Borkakoti and Kavindra Mohan Borkakoti as legal heirs. In 1981, Purnachandra Nath went to the service place of his son in Karbi Anglong, delivering possession of the entire Schedule A of land to Nizamuddin, Samsuddin, Najimuddin, Serubali, and Jalaluddin for cultivation on Shukti basis. And Leela Borkakoti was entrusted to look after the said land. Lahore Borkakoti collusively behind the back of Purnachandra Nath mutated name of Bhagirath Nath as sharer, name of Leela Borkakoti by inheritance, and his name and by inheritance on the same day dated so and so. So, Lordship, on these discussions, the sale deeds were held to be invalid. Page 92, Lordship. last portion, page 92. First paragraph, last 6-7 lines, Lordship, as the vendor Lahar Borkakoti.
Page number?
92, Lordship.
Yes.
As the vendor Lahar Borkakoti was not proved having saleable right over the suit land, the transfer of the property by registered sale deed number, these 3 sale deeds, Lordship, were not valid and found to be void. As such, the plaintiff could not prove his right, title, and interest over the suit schedule B land. Accordingly, he is not entitled to recovery of khas possession. The same line, Lordship, first appellate court also, Lordship, decided this suit to be, Lordship, dismissed my suit, Lordship. But first trial court, Lordship, on the basis of these discussions, later on held that there is no cause of action. That issue was reversed by the first appellate court. First appellate court says there is cause of action, but the Lahar Borkakoti has no saleable right. Those sale deeds are void. So I have formulated these substantial questions of law, page 6, Lordship, 2, 3, and 4. When there is no counterclaim, no prayer by the defendant's, Lordship, the courts below cannot declare my sale deeds.
3 and 4.
3, 4, Lordship, 2, 3, 4.
2, 3, 4.
Yes, Lordship. As because registered documents carries a presumption, Lordship, along with that. On that regard, one substantial question of law, and another one, Lordship, there is no counterclaim by the other side defendants. In spite of that, Lordship, the sale deeds were declared as void. There is no stay application of Lordship, only suit was for right title, interest, and recovery. They are already possessing the suit lands.
Whether they have filed any execution case?
No, Lordship. There is no counterclaim from the defendant side. They are
No,
possessing-
whether execution case is filed.
No, Lordship, they are not file any counterclaim, so there is no prayer from them, Lordship, so they cannot file any counter execution.
Okay, take down. Heard Ms. Sodore, learned counsel for the appellant. The second appeal is directed against the judgment and decree dated 6/6/2024 passed by the learned civil judge senior division Moregaon in title appeal number 10 of 2018. Also, it is to be noted here that by the impugned judgment and decree dated so and so, the learned first appellate court has dismissed the appeal, thereby affirm the judgment and decree dated 8/8/2018 passed by the learned Munsif number on Moregaon in title suit number 50 of 2012, whereby the learned Munsif has decreed the suit of the plaintiff.
Dismissed.
No, by which the suit of the plaintiff was dismissed. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated so and so so and so. The second appeal is admitted on the following substantial question of law. Number 1. Whether the dismissal of the suit of the appellant struck plaintiff is correct in presence of their purchase deed, that is registered sale deed, or whether non-consideration of the registered sale deed by the learned courts below vitiates both the judgments. So, two sentences are clubbed together here.
Lordship.
The second part we can take
Lordship.
whether non-consideration of the registered sale date.
It's by both the courts below as we sheeted both the judgments.
First one delete. Whether non-consideration of the registered sale dates by both the learned courts below had vitiated both the judgments. Number two, whether the courts below committed wrong by not considering the purchase deed exhibit 11, 12, and 13 as valid in spite of the law that the registered sale deeds carry presumption of genuineness. So 2 and 3 are almost same.
Almost same, Lordship, and the 4 is most important, Lordship.
So instead of both 2 and 3, we'll take third one,
Yes, Lordship.
number 3. Whether in absence of next any pair or counterclaim by the defendants, the learned courts below are correct in declaring the purchase registered sale deed of the appellant stroke plaintiff as void.
Any other substantial question?
The court may also consider framing of any other substantial question of law if found necessary at the time of hearing, with due notice to the parties. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. SSL also call for the records from the learned courts below. List the matter after 4 weeks. Stay petition.
While issuing notice.
Stay petition, is there any stay
No,
petition?
no, Lordship. Lordship, while issuing notice, we have to take permission from the courts. If we serve notice with only the appeal memo, Lordship, it's a volume.
Only?
Only with appeal memo, Lordship. And later on, after their appearance, I'll serve the entire appeal memo, as because
Okay.
there are so many respondents.
Okay. On the pair being made by Ms. Sodore, learned counsel for the appellant, permission is accorded to send the copy of memo of appeal along with the notice.
Obliged, Lordship. Only the memo of appeal, Lordship.
Okay.
Obliged, Lordship.
Timing item number 45 for bail hearing.
This second round of litigation, Lordship, earlier order, your Lordship will find page 27. And paragraph 6, Lordship may kindly see.
Page number?
Page 28, the relevant portion which I am relying, it starts from page 27.
Yes.
Paragraph 6. Behind it. 6, 7, 8, and 9.
So what is the ground?
And ground is that, Lordship, this honorable court already held that there is delay in the trial, Lordship. And that has affected the right of the petitioner under Article 21.
That is not disputed, Lordship. That is already in paragraphs 6 and 8. It is there.
When he was arrested?
He was arrested on 6/3/2022. 6/3/2022.
When charges was framed against him?
Charges were framed on 28/9/2022.
On?
28/09/2022.
How many witnesses cited in the charge sheet?
9 witnesses.
And how many witnesses examined till date?
1 witness. But fact of the case is that, let's say, one person was shown in the charge sheet as absconder. He did not appear, nor a case was split against him. Without those things, let's say, that charges were framed. Thereafter, the learned trial court found that one of the accused is absconding. So entire proceeding was stayed thereafter. And the case is still at same.
Who stayed it?
Lordship.
Who stayed it?
That prosecution witnesses were not examined thereafter.
No, who stayed the proceeding?
Not exactly, stay order was passed, Lordship, that further witnesses were not examined thereafter. Because of that, he was issued, warrant of arrest was issued against that co-accused instead of summon to the witness, Lordship.
No, in the order dated 38/11/2023, this court has directed to split up the matter.
Lordship.
Why it was not split it up?
That I have no instruction.
Mr. Das?
Lordship, updated LCR call for status report that is there by now, but it is not stated why this has not been split up, Lordship. On 23/7/2024, issuance of NBW was there, Lordship.
No, that's all right. Splitting up the case against that person. Court can proceed against the person who is languishing in jail again.
On earlier occasion, updated status report was called.
So the witness already examined, is he official witness or Caesar witness?
Caesar.
Whether he has implicated you or not.
Identified.
That implication is there. Well, I am not on merit of the case, Lordship, at this stage. Because there in the last order, Lordship, direction was there to conclude the trial within 6 months or that.
No, Mr. Ahmed, that direction now cannot be issued by High Court. In view of judgment of the Supreme Court in Allahabad High Court Bar Association case.
That absolute, in my humble understanding, Lordship, that absolute bar is not there. And in the present case, if your Lordship sees page 30, last 3 line of that paragraph 9, it is that considering the fact or given fact of the present case, that direction was there. Lordship.
Now, that direction was for session judge. What happened? Whether you have filed any application before the session judge?
Bail application we have filed. So we have mentioned about that order also.
What order was passed by the session judge?
That I have enclosed at page 31. In this bail application also I have mentioned that.
So the trial court held that the quantity of contraband substances recovered from the possession of the accused is of commercial quantity.
Lordship.
How do you satisfy the requirement?
That Lordship, that
Section 37.
One satisfaction I am relying on, Lordship, but
Paragraph 4, Lordship.
The question is, can we read this judgment as precedent?
But because here also that direction was there to conclude the trial,
Mhm.
and this no criminal antecedent is there. And the delay in trial that therefore also that considering that substantial compliance of section 37. Fact charges were framed around 2 years ago, at 28/9/2022. And we are in 9.
Yes, Mr. Das, what is your submission?
Lordship, may apply for, they may approach before the trial court, Lordship, for splitting
have
up the
already
case,
applied.
Lordship.
For?
Splitting up the case, Lordship. 317(2), Lordship. Moreover, the independent witness implicated them, Lordship. Independent witness, Lordship, identified them, Lordship, implicate them. It is commercial quantity, Lordship. And they found in a conscious position. Okay. Out of 9 witnesses, 4 are independent witnesses, Lordship. And 1 has also.
All right, there are 4 independent witnesses, but you examine it.
Lordship, because of this person, Lordship.
And one thing also just.
Heard Mr. Ahmed learned counsel for the accused and Mr. Das learned additional for the state respondent. Argument concluded, order is there.
All right.
File number 28 for orders.
Wait, please. This IA for condonation of delay.
IA is first.
For condonation of delay in filing petition for substitution of the name of legal heir. Appellant number 2. Appellant number 2 expired.
So first we have to condone the delay.
Yes.
But what is the ground for which you could not file the petition in appropriate time?
Really, my lord, the grounds have been cited, my lord. They are the paragraph number 3 and 4, my lord. Actually, she was not aware, my lord, that substitution is required to be done, my lord.
as there were other appellants.
She was not aware of.
But substitution has to be done, my lord. For that, she has to take step, my lord.
When the appellant
Expired, my lord.
expired.
Paragraph 2, my lord, on 10/6/2014.
Hmm. And when you came to know about the same?
I came to know, my lord, on 18/3/2020, my lord. During, my lord, thereafter COVID started, my lord. When she went to meet the local council at Dibrugarh, subsequently, when the COVID period is over, my lord, immediately she has filed, my lord. And this annexure 2, my lord, is the order for extension or limitation during COVID period.
And that's all right. There is no dispute about the same.
Genuine prayer, my lord, only thing is that respondent notice was also served.
Pardon?
Notices or service is also complete, my lord. So far.
No, merely because the other side has not appeared and contested the petition, we will not grant the
Yes,
relief in a routine manner.
yes.
You have to explain it.
So that is explained, my lordship, in paragraph number 3. If I read then lordship. Paragraph 3, it was stated that the appellant number 2 expired on 10/6/2014, my lord. And applicant is not aware about the legal requirement of filing substitution petition. And when local
Heard Mr. Borua, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicants for condonation of delay of 2,106 days in filing the petition for substitution of the legal heirs of appellant number 2 in RSA number 50 of 2014. Mr. Borua, learned counsel for the applicants, submits that the applicants came to know about the date of appellant number 2 on 10/6/2014. No, submits that the appellant number 2, Mohibul Hussain, suffered demise on 10/6/2014, and the applicants came to know about the same on. Who is that you came to know?
18/3/2020.
On 18/3/2020. And she was not aware of the legal requirement of substitution of the legal heirs within a period of 60 days. Mr. Borua further submits that when she came to know about the legal requirement of substitution of legal heirs, then the COVID-19 pandemic was prevalent and normal functioning of the court were suspended. And in Somoto case number 3 of 2020, Honorable Supreme Court had extended the period of limitation from which period to which period?
Page 16, my lord. 15/3/2020. Page 16. Paragraph 8.
Extended the period from
15/3/2020.
page number?
Page number 16, 1 6. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16. 16
From 15/3/2020 till 2/10/2021. And immediately about knowing the legal requirement of impleting the legal heirs of the appellant number 2, she had approached this court by filing the present application, and that the delay is not intentional, rather it is circumstantial, and she has and they have sufficiently explained the same, and therefore Mr. Borua has contended to allow this application. It is to be noted here that the respondent had not turned up, though service deemed to have been completed. Having heard Mr. Borua, learned counsel for the applicant, I have carefully gone to the petition and the documents plus in record, and also the statement and environment made in the paragraph number 2 and 3 of the application, and also the order of Honorable Supreme Court in Somoto case number 3 of 2020. Dated 23rd September 2021. Where it appears that the appellant number 2 suffered demise on 10/6/2014, and the applicants came to know about the legal requirement of impleting the legal heirs only on 18/3/2020. And at the relevant time, COVID-19 pandemic was prevalent. And in the Somoto case number so and so, the Supreme Court has also extended the period of limitation from 15/3/2020 to 2/10/2021. Thus, it appears that the delay of such and such days is sufficiently explained here in this application, and therefore this court is inclined to allow the same. Delay of such and such date in filing the substitution petition stands condoned. In terms of this IA number so and so, stands disposal. Any other IA?
Well, there are two other IA, one for substitution and other is for setting aside abatement. Substitution. IA 958 is for setting aside abatement.
Heard Mr. Porwa, learned counsel for the applicant. This interlocutory application is preferred under order 22 Rule 3/4, read with section 151 of the Code of Civil Procedure for substitution of legal heirs of the appellant number 2 in RSA number 50 of 2014. It is to be noted here that notice was deemed to be notice was due to duly served upon the respondent, but the respondent chooses not to contest this application. It also appears that the appellant number 2, Mohibul Hussain, suffered demise on 10/6/2014, leaving behind in legal heirs who are required to be implemented in the RSN number 50 of 2014. But having considered the submission of Mr. Borua, learned counsel for the petitioner and applicant, and also considering the facts and circumstances on the record, this court is inclined to allow this petition. The legal heirs of the appellant number 2 be substituted in RSA number 50 of 2014 in terms of this IA stands closed. Okay. Not substitution for setting aside of the allotment.
Item 29.
Next is the lordship. Interlocutory application on condonation of delay lordship, 956 days. Lord.
What is the ground for delay?
Delay your lordship, paragraph 7 and 8, 9 lordship. Paragraph 7, 8 and 9 lordship.
So is economic hardship is a ground for condonation of delay?
Lordship.
Hmm? Any other ground?
Other ground is a lordship. Family has been suffering in COVID-19 lordship. Paragraph 8 lordship.
When the judgment was pronounced?
Judgment lordship 19/9/2017 lordship.
So COVID started in the year 2019. In between, what happened?
20 lots. COVID 20.
Pardon?
Started in the year 2020.
Started from 19. Therefore, it is called as COVID-19.
19 lots.
You have for respondents.
Yes, Lordship.
You have filed objection here.
I have filed the objection.
What is the
Lordship, both
objection?
the grounds are not tenable since merely stating that he is poor. So how come he overcome poverty now? So not tenable, Lordship, and 950 days, 2.5 years is a much delay. So it should not be tenable. And the suit which was dismissed was also bogus. It's a meritless suit. The petitioner has plaintiff, without disclosing the identity of other legal heirs, made himself only as a party. It's a bogus suit. Suit was dismissed on a single count of non-jointer of necessary parties. 5 year ample year were there before him to implead the undisclosed legal heirs, but the same has not been done. It's not, he's just trying his luck. Otherwise, could be again abuse of.
Your objection with the page number?
Page number, Lordship. Actually, from my objection onwards, I guess the serial number being started after petition. It is 1 in my objection. Lordship. It is starting, the number is starting from 1 in my objection. It will be, I guess, 26 onwards. Lordship. Since the IA is up to 25, page number 25 must be from 26. Lordship. Filed on in the month of July 2023, Lordship. Not a single day is satisfactorily explained, Lordship. Not a single document has been relied to give effect to any of grounds.
Where is the finding of the trial court?
Judgment is at page number 20, page number 9, Lordship. Judgment is there.
Page number 9.
Page number 10, 10.
Nine. 10 is the part, relevant part. In fact, 11 last para, Lordship, from bottom. Proforma demand on Dimbes will file written statement and stated that the suit is not maintainable and the same is bad for non-maintainable. This is the count undertaken by the trial court.
No, where is the finding?
Finding is on the page 16, Lordship. Page 16 of the year.
So the dispute is between the members of the same family.
Yes, Lordship.
Yes, Lord.
Okay.
He ought to have filed a separate suit, Lordship, in spite of.
Pardon, Mr.
PK Google, Lordship.
Gogoi, learned counsel for the applicant, and Mr.
Yes, sir, my Lordship, for the
Yes, sir,
respondents.
learned counsel for the respondent. Argument concluded, order reserved.
Keep your message.
I do.
Item 30.
Record
Wait, please, your lordship. Your lordship, in this matter, service is not complete upon the respondents. Kindly allow us to take fresh steps upon the respondents.
Heard Mr. Dr. Learned counsel for the applicant. Appellant, Mr. Dr. submits that he may be granted an opportunity to take a step upon the respondent's pair is allowed. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
31. May I please, Your Lordship. In this case, I have taken steps upon respondent number 1 and 3, my lord, on 18/9/2022. Document number 4 and 5. I've already taken steps. Both way, my lord.
So the office note dated 18/9/24 indicates that you have not taken any step upon respondent number 1 to 3.
I have taken steps, my lord, now.
When?
18-9, my lord, 18-9-2024, both way, my lord, by postal Talavana as well as non Talavana.
Heard Mr. Jay Sharma, learned counsel for the applicant, and Mr. Dutta,
For respondent number 2, your lordship.
respondent number 2. Office note dated 18-9-2024 indicates that no step has been taken up on respondent number 1 and 3. However, Mr. Sharma submits that he has taken speak upon respondent number 1 and 3 on the same date. Accordingly, it is provided that rest is released the matter after 2 weeks, awaiting service report upon respondent number 1 and 3.
Well, all right. 32. Your lordship, so this I application is for honoring the delay in filing.
Pardon?
This I application is for honoring the delay, your lordship, of 431 days in filing, your lordship, the regular second appeal. Your lordship, the grounds are stated in para 4 and 5, your lordship. Mary.
Ground number?
Para number 4 and 5. My application.
Yes, you have filed objection here.
Lordship, and
Where?
another thing, lordship.
Page number?
Page number, lordship. Objection, lordship, para 5, lordship. And 6. Lordship, I have calculated delay is 579 days, actually, lordship. Petition mentioned as 431 days. I have calculated that.
No, the registry has already calculated.
Lordship, excluding the COVID period, lordship, 579 days.
We'll start from 13 to 20.
8 times the past is 9. It is for
That will I will go through your lordship. But here, your lordship, may I place before your lordship case law, year 1987, your lordship. May I place before your lordship? That is your lordship, collector, land acquisition, Anantnag and others versus KG and others. So she may kindly turn the next page. There are 3. The subpara 1 starts from point number 1.
No, but you tell me whether this economic condition is a ground for condemnation of delay.
Because your lordship, the day this order was passed, thereafter your lordship during those times COVID period was very much prevalent at that time, and he was by professional driver during that time. And for that reason, he couldn't able to have enough money to engage counsel as well as to pay the court fee.
No, the law of limitation is same to all the persons. Not different for the drivers.
But may I read one citation, Your Honor, kindly?
Citations are law is well settled.
Yes, that's true.
Merely stating that there was economic hardship, can we condone the same? Because already in favor of the other side, right is created.
But once your lordship, this matter is condoned, your lordship, there's substantial question which has been drawn between the lordship will decide your lordship. The thing is, your lordship, that ordinarily litigant does not stand to benefit by lodging an appeal late, your lordship. That's year 1987, your lordship. If your lordship go through this law. So during those time, your lordship.
What is the decretal amount?
5 lakhs.
5, sir.
Okay, we will see. Headmaster, your good name?
P. Sharma. P. Sharma.
Learned counsel for the applicant and Mr.
M. Shosen, sole respondent.
Learned counsel for the respondent. Argument concluded, order reserved.
May place it, lordship. May place it.
May I pray your lordship one thing? I'm appearing on behalf of Mr. I. Chaudhary actually, he's out of station. So on his behalf, I'm
Okay.
moving this application.
33. 33.
Wait, please, the lordship. As per the office note dated 39/24, the service report is not complete, madam. For respondent number 1 and 4, service report is awaited, and for 2, 3, and 6, there is an insufficient address.
So I have not taken a step.
I have taken steps, insufficient address, they are saying, my lord, it has come back. An insufficient address. I have to take again a fresh steps. I want, my lord, the respondent number 3 and 4 are drivers. They should be stuck off, my lord. They may be stuck off.
At their risk, lordship. And we need to file objection, lordship, in any time because the delay is 1,249 days.
Okay, heard me, sir.
A. Bhattacharya.
A. Bhattacharya, learned counsel for the applicant, and Madam Ardas Mazumdar, learned counsel for the respondent number 1.
5.
5. Respondent number 5. Office note dated 13/9/2024 indicates that no ID card nor answer notice in respect of respondent number 1 and 4 received by the section. It is also indicated that the learned counsel for the appellant has not taken step by usual process pursuant to order of this court dated 2/2/2024. The learned counsel for the appellant submits that he will take fresh step upon respondent number 1 and 4.
Respondent number 2 and 6. 1 and 4 is awaited service report, my lord, as far as.
No, you are praying for.
And 3 and 4 to be stuck off.
3 and 4.
Both of them drivers, both drivers.
At this stage, Mr. Bhattacharya submits that the name of respondent number 3 and 4, who are driver and
Both of them drivers.
Driver
Two vehicles were involved.
of the vehicles. Maybe struck off from the area of this appeal. Having considered the submission of Mr. Bhattacharya, learned counsel for the appellant, it is provided that the name of respondent number 3 and 4 may be struck off from the area of this appeal at the cost and risk of the learned counsel for the appellant. So now you have to take a step upon respondent number 1 and
1 and 4 already service.
no, 4 is struck off.
Yes. 3 and 4 is struck off. Only for 2 and 6.
2 and 6. In view of the submission of Mr. Bhattacharya, learned counsel for the applicant, it is provided that he shall take fresh step upon respondent number 2 and 6. List the matter after Ms. Ardem Mazumdar, learned counsel for the respondent number 5, submits that she may be granted time to file objection in this application. Here is accordingly allowed. List after 4 weeks.
Yes.
34.
May I please, your lordship? Lordship, can we see official dated 17/9? Lordship, respondent has appeared as serious, lordship.
Part Miss,
D. Devi, lordship.
learned counsel for the petitioner.
Kindly fix the matter, lordship, for admission any date before 2011, lordship.
Office note dated 17/9/2024 indicates that Ukalatnama has been filed on behalf of the sole respondent, but no one entered appearance on his behalf before the court today. Said office note also indicates that a scanned copy of the LCR has already been received via email. The learned counsel for the petitioner submits that since service is completed and the LCR has been received, the matter may be listed for admission hearing. Here is allowed. This is a list the matter on immediately after reopening of the vacation.
Item 35.
Today I received a copy of this affidavit of opposition, but they did not supporting the this one, no? On the affidavit is there. There's no any receipt with the affidavit. We claiming the area amount, but they already said that they will pay 12,63,000 to us, but we did not get any receipt from them.
Here in this interlocutory application, the respondent side paid for realization of a huge amount of rupees 13,49,500. Lordship does very well that there must be foundation in the original suit to get such type of relief. If your honor kindly peruse the plan, they have no at all such foundation in the plan and no court fee has been paid. And it is the duty of the plaintiff to plead proof as well as to pay court fee.
This case has already originally fixed for the eviction of the opposite party, which has already court orders. The court already ordered to evict the hotel premises, but till 2016 to 2024, this case was pending before this honorable court only for hearing, and that long time of 12 years they did not pay any hidden amount to us. This is the only source of income of this petition.
The Appeal is pending.
from 2016.
For hearing. LCR is yet to be received, Lordship.
2016.
Okay.
Right, order dated 5/4/2017, appeal was, this revision was admitted for hearing. Accordingly, record was called for.
Okay, in Sharpie, take down heard Miss Mary, learned counsel for the petitioner. And Mr.
R. Ali, Lord.
R. Ali, learned counsel for the respondent. Office note dated 18/9/2024 indicates that LCR has not yet been received. Accordingly, it is provided that registry shall issue reminder to the learned trial court for transmitting the record without further delay. List the matter after reopening of the application.
Interim order passed earlier may be continued till disposal of this
Interim order
revision
passed
application.
earlier shall continue. Continue.
But this, I can be disposed of, Lordship. I have some supported judgment. So this is not at all maintainable.
They still uses our premises for the hotel. They still uses our premises and they earning the money from our premises. But we did not get the, if they have not paid this only for the court process, they will be paid.
No, but
But
without
not-
hearing the appeal, can we pass any order in this IA?
Yes, Lordship, interlocutory application has some limited scope, Lordship. That cannot override the main plant and main relief, such in the main plant, Lordship. Here, they have paid court fee of only 2 months, that is February and March 2012. They also did not pay 1 year rent, which is mandatory as per judgment of our High Court, Lordship. So for
Okay,
filing us
heard
against-
Miss MD Medal, learned counsel for the petitioner. Applicant and Mr. So-and-so, learned counsel for the appellant. Let this petition be heard along with the CRP number 4443 of 2026 on next date.
Highly available.
36.
But there is an award in connection with the death of the deceased mother, 27,30,400 by the Borbet MSCT Court. Then my friend, on behalf of the
No, Mr. Biswas, this application you have filed under Article 226.
This is very interesting case, my lord.
Huh?
It is a case of appeal. Therefore, allowing this honorable court to realize this awarded amount. So that my 226 is not maintainable. If it is maintainable, go to the Bakija court, some other cases. Now, question is that, my lord, I have some difficulty. I have not filed this application. I have to file it in some application for modification of the order because this honorable court is there is a mistake. I have prepared all these things. Within next week, I file it.
But it will be 227 minutes.
Not 227. How it is 227?
Yes, 227.
High court order is a 227. It is a subordinate court. It is a subordinate court.
It is not subordinate court. It is
It is not a subordinate.
High court can invoke 227.
No, you can file a review petition.
Not, subject matter is little bit different.
Provided it is,
Let me submit. Please wait. There is an award of 27 lakhs, my lord. 27 lakhs,
It is accurate fact, my lord.
30,400. But my lord, in the appeal they have filed, it was compromised. In the
Not
appeal.
compromise. Not compromise. My lord, what?
Let me submit. Then, my lord, they are, as per their own calculation.
No, not on calculation.
Mr. Biswas.
But they are not allowing me to submit. Kindly,
That is, I have submitted this, my calculation.
No. Mr. Biswas.
Yes, ma'am.
You first correct this cost title of this application.
I'll do it.
In the meantime, allow me to file alteration modification.
No order is required.
They have already agreed, but honorable court has passed the order
my lord,
on their calculation.
No. I have already submitted. This is a wrong calculation.
Mr. Biswas, learned
There
counsel
is
for
some,
the
that is why I am
applicant
allowed to
submits
file.
that, he may be granted some time to correct the cost title of this application. Pair is accordingly allowed.
It have to go to the appropriate court, my lord, because it was passed by my honorable court. I'll modify the order.
My lord, at the same time,
After 1 week.
my lord, at the same time, I may be allowed to file an alteration modification of the order. Because there is a.
The permission is not required. You can file the petition.
Yes, I'll file the petition.
37.
May please your lordship. File of IA for condonation of delay. Lordship, first time it is listed. Lordship, notice to go, lordship.
21 days.
21 days.
Let notice go.
Lordships.
Heard Mr. R. Sharma, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 21 days in preferring connected appeal against the judgment and decree dated 3/5/2024. Judgment dated 3/5/2024 and decree dated 7/5/2024 in TS within bracket divorce number 06 of 2021 passed by the learned district judge Lakhimpur, North Lakhimpur. Where is the petition? Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post AD and also by usual process. List after 4 weeks.
Highly ordered. Item 38.
Maybe. Lordship, we have filed for respondent number 8. Sometime may be guaranteed, lordship, for repeated in opposite.
How many respondents are here?
8.
8 respondent lordship,
Eight.
8, and lordship, if your lordship peruse the last order of this honorable court, direction has been given to the standing counsel of respondent number 6 to receive some instructions as regard the respondent file.
Instruction not yet received, my lord. So, my lord, let this matter come after 10 days. In the meantime, I'll get the instruction. After that.
Okay, heard Mr.
D1000 lordship.
Learned counsel for the petitioner and Mr.
Ace Islam on behalf of R.S. Udhari.
A. Islam on behalf of
Ace Islam, lordship.
on behalf of
R.S. Udhari.
R.S. Chaudhary. Learned counsel for the respondent number
8.
8. Mr. Islam submits that you have filed Ukalodnama.
Yes.
When?
21/8/24.
That on 21/8/2024 he has filed Ukalodnama. He may be granted some time to file affidavit in opposition. Pair is allowed. Also heard Mr.
Arthur, standing counsel, tribal affairs. 3 and 6, respondent number, my lord.
Heard her extending counsel for the respondent number 3 and 4.
3 and 6.
3 and 6 and Mr. Soikia. Respondent number 4 and Mr.
B.
Hazarika, learned counsel for the respondent number 5. 7. Mr. Dhor, learned counsel for the respondent number Swinson submits that
Instruction is awaited, my lord. Instruction is awaited.
that instruction is awaited and the matter may be listed after 10 days. Pair is accordingly allowed. Recess shall list the matter after 10 days.
47.
I'm obliged, lordship.
Item 47.
Here in this case, there is a delay of 1421 days delay, my lord, filed by the owner, my lord. Here, there, my lord, learned member directed to pay the amount, my lord, to the claimant, my lord. Here, what is happened actually, my lord, after filing this, after this judgment, my lord, passed by the learned member, my lord, petitioner has no knowledge because he went to Silsor, my lord, shifted to there at Silsor, my lord. Subsequently, he has come to know that for pay and recovery order was there, my lord. Insurance company, my lord, filed one case before the, my lord, for recovery of that amount. So, my lord, as there is a judgment, my lord, because in this judgment, because of the, my lord, fake license that has been, my lord, observed by the learned member, my lord. That has, on that ground, my lord, pay and recovery order was passed by the learned member. And what is happened, my lord, that amount has been directed to pay, my lord, to the owner.
No,
of
no,
the-
now you tell me what is the ground for delay?
Delay, my lord, shifted, my lord.
Pardon?
My lord, this owner, my lord, shifted to Silchar, that's why, my lord, he. I have stated in paragraph 3 and 4, my lord, kindly peruse your lordship. I am, my lord, 2308/23. On that, only reason, my lord.
Paragraph number?
Paragraph 3, my lord.
What is the ground?
Ground, my lord, I have stated that he has shifted to Silchar, my lord, from Gwalpara. That's why he has no knowledge because Lanet Council, who was conducting the case in Gwalpara court, my lord, he also did not inform. Subsequently, coming to know about the filing of the miss case, my lord, R, case number filed by the insurance company, receiving the notice, my lord, he has contacted with the Lanet Council of Gwalpara and he has applied for the certified copy and subsequently got it and filed this case. Because he has shifted, my lord.
When he was when he has shifted?
Shifted, my lord.
On who is that?
I have not mentioned actually here, my lord.
Then?
Yes, my lord.
Mere averment that you have shifted from Gwalpara to
Silchar, my
Silchar.
lord, along with the family.
Would it be sufficient? You file additional affidavit?
Yes, my lord.
Indicating the date of shifting?
Shifting, my lord, yes.
On the appear being made by Mr. H. Das, learned counsel for the applicant, raises shall list the matter after 1 week so as to enable him to file an additional affidavit, bringing on record the date of shifting of the applicant from Gwalpara to Silchar.
48.
Lordship, in this case, additional affidavit is filed by the bank, Lordship, and I want to file an reply to that. And my client is suffering from some. She is in a hospital. She is in Itanagar.
Heard Davis, learned counsel for the and Dave, learned counsel for the applicant, and Mr. Sharma for respondent number
3 and 4.
3 and 4, your Lordship.
respondent number 3 and 4.
And I am the IA applicant, your Lordship.
This IA is for what purpose? IA 2642.
3368. That is 2642. It is regarding injunction law. Already granted by this honorable court. And interim order may be continued.
This has been disposed of, IA number 2642.
No, Lordship, it is pending.
3368, your Lordship.
They are filed and vacating the
No,
order.
today only this IA 2642 is listed. You see the cause list?
Yes, Lordship, there is 3 cases listed. It is by order, I don't know about that.
IA number 3368. It is
Yes, sir.
for the
This is against
Vacation.
the order dated 8/9/2023
For vacation of the injunction.
for vacation of the injunction order.
That was,
okay. So you want to file objection?
yes, Lordship, there is a
Your
additional.
Lordship, short date may be given, your Lordship. because this-
She is not
we
in a
have-
position to come, Lordship, because
Heard Mr. Sharma, learned counsel for the applicant, and Ms. Dev, learned counsel for the respondent. Ms. Dev submits that she may be granted 2 weeks time.
oh, Lordship, it is not possible because due to back problem, Lordship. Earlier also she was.
Okay, 3
hospital.
weeks time.
Lordship, interim order may be continued.
So
Passed in
3 weeks time to
2642.
file objection in this application. Pair is accordingly allowed. Recess shall list the matter after 3 weeks. Till then, interim order pass earlier shall continue.
In 2642, Lordship, specific, 2642.
Okay, 2642 heartfully. Interim order shall continue.
49.
Obliged.
Yes, my lord, actually the respondent number 1 is expired, so in his place we want substitution of his wife and son. And then we came to know about the matter from the execution suit that is being held in the trial court. So,
Whether this application is filed within time,
yes, my lord, it is filed within time only.
when the person concerned died,
My lord, only on 1/6/25/24, when we appeared in the in execution suit, then only we came to know about this. Earlier, we didn't have any idea about it.
okay, this application is application under order 22 rule 4 CPC is prepared for substitution of legal heirs of respondent number 1. Respondent number 1. When he died,
So we do not have that knowledge, my lord. We just came to know about that. He has been substituted for this in matter. And then the.
let notice be issued to the respondents returnable in 4 weeks. They be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
My lord, in this case, actually, in the main suit also, we are supposed to send the notices. That is the RFA. My lord, in that case, we need to file them, send the notices into this case.
Pardon?
In the main suit RFA, in that RFA also, it has been ordered, has been passed for giving notices, but then this substituted person.
No, but only after substitution of the legal heirs, so we will proceed with the RSA.
RFA.
For hearing, item 39.
Appeal against judgment of the real estate appellate tribunal. My lord. I don't think, my lord, we'll be able to start and conclude the hearing matter.
Yes. So let us fix it on a hearing date.
Let it be fixed on a hearing date, my lord. If it is convenient to my learned senior friend, my lord, can it be on 29th of October?
29 October.
It has to go to October.
26th, can we make an attempt, man? 26th, our client has an urgency because
26th of
September.
Before the vacations, my lord. This motion week will be declared, my lord. Next 2 days. In 2 weeks.
No, motion week will be from starting from 30th.
26th is, I have got some difficulty, my lord. 26th, I am not in. My out of station.
26 May.
Otherwise, our
September.
urgency is there because
Before vacation, not possible.
we have an urgency because we have purchased a villa, my lord, from the
Maybe,
builder.
but your matter may not reach on that day.
90% of the price we have paid, we have not given possession.
My lord, if there was an interim order directing him to register the sale deed, he refused, my lord.
90% of the amount we have paid, my lord. For the 10%, there is a dispute.
Okay, immediately after reopening, you suicide it.
My lord.
29th, immediately.
Let it be 29.
29th.
29. All right.
Hearing.
As agreed by learned advocates of both the parties, raise is a list the matter on 29th of October
Obliged.
for hearing. Any other matter?